this case pertaining to some matrimonial issue or some data protection issues or some matrimonial issues, this cross-border cooperation plays a very important role. And before I share my thoughts and views in this regard, friends, ladies and gentlemen, distinguished attendees, I would like to start with my presentation with a disclaimer that I, being a civil servant and an officer of the government of India, I cannot enjoy the absolute freedom of speech and expression. So all the views and thoughts which I will be sharing with all of you will be my personal thoughts and personal views, and nowhere reflects either on my government or on my department. So they cannot be quoted or referred as the views of the government of India or the views of the Department of Legal Affairs. These are purely my personal views. With the help of illustrations and examples, I will be sharing. Give me a moment to share my presentation. Is it visible or is not yet visible?
Yes, sir. It is
visible.
It is visible. It is visible.
Visible. Is visible. Okay, fine. So let us start the journey of mutual legal assistance in criminal matters and challenges. And India posed really a big challenge when we are handling one of the important cases. You might have heard about this, or some of you might have read about this in the newspapers. A very important, interesting case pertaining to space, the Department of Space, Ministry of, which is under the control of the Prime Minister. The Department of Space, popularly known as Antrix Devas case. In Antrix Devas case, we faced a big challenge about this mutual legal assistance and how it is, and in what are the challenges we face and how we overcome these challenges. I'll explain you with the help of illustrations and examples. Friends, ladies and gentlemen, it is a duty of the state to protect the rights and liberties of the people, because when we talk about the criminal justice administration, it is more keenly related to the rights and liberties of the people. If a person is arrested, there's a question of his right and liberty. If a person is detained, there's a question of life and liberty of a person. If you conduct search and seizure, there's a question of right and liberty. So therefore, it is a duty of the state to protect the rights and liberties of its people, to secure the innocent and to punish the guilty. In every civilized society governed by the rule of law, there is a criminal justice system in place for this purpose. In India, criminal justice system is posing several challenges. When guilty go unpunished, the faith of a common man in the system will be shaken. It is both the common perception and the reality that the crime continues to increase in India. In fact, it proliferates. With the advent of the globalization, because of the globalization, crime has no barriers, as rightly mentioned by the learned director of prosecution in the introductory remarks. So there are no borders for the crime. It became a global phenomenon. So one of the challenges today is how to punish a criminal who is residing in another jurisdiction. There are several issues that may arise when you handle a case which has a cross-border connections or which has some connection with other jurisdictions. If a criminal escapes to a foreign territory or a foreign jurisdiction, or if a witness is residing in a foreign territory or in a foreign jurisdiction, how to get the witness for examination, how to get the accused who is residing in a foreign territory, or if a document is to be served or processed in a foreign jurisdiction, how to get the document processed. All these are various questions that may linger, that may arise when we talk about criminal justice administration, which is having a cross-border connection in view of the or in advent of the globalization, or in advent of the mass trade across the world. At one point of time, kings used to fight with each other for the sake of expansion of their kingdoms. Today, the corporate kings are fighting with each other for expansion of the corporate kingdoms, their corporate kingdoms. In this regard, the digitalization and artificial intelligence also played a very important pivotal role. So today, the question today is not only about this mutual assistance across the borders, but also about the issue of the use of artificial intelligence in commission of the crime. You might have heard about the deep fake or the fake impersonation. All these are the outcome of the artificial intelligence. So how these can be overcome? All of a sudden, there may be a call, as if it is a call from one of your seniors or one of your superiors.
Screen, sir.
Yes. Yes.
మీరు కనిపిస్తున్నారు కానీ స్క్రీన్ కనిపించట్లేదు సార్.
Just give me
You
1
are not
minute.
sharing the screen, sir. You are not sharing. We
Okay,
are not.
okay. I'll just give me 1 minute. Just give me 1 minute.
Sir, your video is visible, sir. I hope
screen వస్తుంది
you are
సార్.
all
స్క్రీన్ వస్తుంది సార్.
looking very clearly, sir. No problem at all. You are visible and your voice is audible. Everything is perfect, sir.
కృష్ణారాయణ గారు చూస్తున్నారు, ఒక్క నిమిషం ఆగండి, వెయిట్ 1 minute.
సార్ వాయిస్ రాలేదు సార్, వాయిస్ రాలేదు, స్క్రీన్ షేర్ కాలేదు సార్.
సార్ బాపట్ల డిసిపి, బాపట్ల డిసిఆర్పిసి సార్ వాయిస్ రావట్లేదు సార్ మాకు.
సార్ ఆళ్ళగడ్డ ఎస్డిపిఓ ఆఫీస్ నుంచి సార్. సార్ వాయిస్ రాలేదు, స్క్రీన్ షేర్
ఒక్క
కాలేదు
నిమిషం
సార్.
అండి, ఒక్క నిమిషము. మనోళ్ళు పవర్ పాయింట్ స్లైడ్ ఇప్పుడు వెయిట్ ఒక్క నిమిషం ఓపీ
స్క్రీన్ షేరింగ్
ఎవరు
సార్.
ప్లీజ్ వెయిట్ 1 minute. జోగారావు గారు ఇప్పుడు పవర్ పాయింట్ కనబడుతుందండి.
సార్ ఆళ్ళగడ్డ ఎస్డిపిఓ ఆఫీస్ నుంచి సార్ కనపడుతుంది సార్ పవర్ పాయింట్.
ఓకే.
Okay. Hope now you are able to see the sharing and the PowerPoint presentation. Is it visible now?
Yes, sir.
So we are just discussing about the duty of the state to protect, as I mentioned and as I referred, because of this globalization, advent of the globalization, crime has no barriers, as rightly referred by the learned director of prosecution in his introductory remarks. So the challenge today is how to get an accused who is residing in a foreign territory, how to get a witness who is staying in a foreign jurisdiction for examination before an Indian courts, or how to process a survey document which is to be served on a national residing in, or a person residing in a foreign territory. Or as you mentioned, as rightly mentioned by the director of prosecution in his introductory remarks, in case of digitalization, in case of the problem pertaining to some digital aspects or data protection issues, how to call an expert from a foreign territory to establish the credentials before a court. All these poses severe challenges for prosecutors and officers of administration of criminal justice like you before the court of law. So therefore, the question today is how to overcome all these issues. And one of the solutions to address this issue pertaining to the cross-border crime is a mutual legal assistance. I don't say that the mutual legal assistance is the only solution for addressing the cross-border criminal issues, but I must say very clearly and frankly that yes, definitely the mutual legal assistance in criminal matters is one of the important solutions to address all these issues. Whether you take the example of Vijay Mallya, or you take the example of the Chusky, or you take the example of the returning or getting the black money that is located in foreign banks. To address all these problems, the solution is the mutual legal assistance. So today we will discuss what this mutual legal assistance is, how this mutual legal assistance can be extended or provided, and is the mutual legal assistance is the only option, or is there any other mode of cooperation between the nations for extending or facilitating cooperation in criminal justice system? That we will see. And that's why I'm saying mutual legal assistance is one of the solution, but it is not the only solution. Friends, ladies and gentlemen, what this mutual legal assistance is nothing but a treaty. I'll elaborate and discuss the same with you with the help of the slides in due course of time. But I must say before that mutual legal assistance treaty, MLAT, we call it in simple sense, is nothing but a treaty. It is a treaty. And entering into treaties and agreements with other countries is one of the attributes of the sovereign. No state can remain in isolation without entering into treaties. For example, China remained in isolation without joining the WTO for a long time. And China later realized that not joining the WTO may prejudice their economic interests. So therefore, China also started entering into treaties, and China also started joining the WTO. So no country can insulate itself with the rest of the world. And the advent of the globalization and enormous advances made in communication, information technology. When I say communication and information technology, it plays a very, very important role in the present days of digitalization and mass communication media. Why? Because the crimes are mainly pertaining to this communication and information. Communication passes from one jurisdiction to another jurisdiction. Suppose if the communication is made from a foreign jurisdiction or from an instrument whose server is located in a foreign territory. So how do you have an access to the communication or the source of that communication that is sent from a foreign territory? A phone call is received from a foreign territory, is a person who is residing in Bangladesh, or who is residing in Singapore, or who is residing in Malaysia, and thereby he is instrumental for commission of a crime, say in the state of Andhra Pradesh. So how do you locate, how do you track the source of that communication? How do you locate the source of information? The communication is a very, very important role. So therefore, entering into treaties is an essential requirement. It is a sovereign attribute, and every country had entered into and is entering into treaties, be it multilateral or bilateral, which have a serious impact upon the economy and the social and political life of its society. So therefore, India is not an exception in entering into treaties with foreign jurisdictions or foreign countries. India too entered into several treaties with various jurisdictions. The treaties can be divided into two, maybe multilateral or bilateral. Multilateral means when more than 5 nations enter into an agreement, they call as multilateral agreements. Bilateral means it's an agreement between 2 nations. For example, all the UN conventions can be quoted as a multilateral treaties, because all the members of the United Nations will be party to that convention, will be signatory to the convention. That is why they are called as multilateral treaties. Bilateral means if there is an agreement between India and Bangladesh, or India and Singapore, and India and Japan, it is called as a bilateral agreement. So entering into a treaties is an essential requirement in the present days, not only to meet the economic challenges, but also to address the issue of the mutual legal assistance in criminal matters. What will happen if there is a treaty, and what will happen if there is no treaty, that we will discuss. But before proceeding to that aspect, it is essential to know that entering into treaty is a sovereign attribute. When a treaty is entered, means it is a sovereign power, the chief executive power of the nation. The President of India will exercise his chief executive power, and thereby will enter into the treaty or agreement with foreign jurisdictions. So that's how the treaties are important. And mutual legal assistance in criminal matters are bilateral treaties entered between the countries for providing international cooperation and assistance. So the mutual legal assistance, the MLAT, is a bilateral agreement between India and various jurisdictions. What are the contents of this MLAT? How this MLAT will play an important role in providing assistance in criminal matters that we will see in due course of time. But mutual legal assistance in criminal matters is nothing but a bilateral treaty between India and other jurisdictions. So far, India has entered into 42 mutual legal assistance agreements with 42 different jurisdictions. This data I collected from Ministry of Home Affairs. This data is till November 2019. Still, negotiations are going on with various jurisdictions for conclusion of the MLAT with that particular jurisdiction. So, in due course of time, this number may increase. And you may ask me one question: what is the significance of this treaty? What is the significance of this number? This number is very significant because the more MLATs you have, the more is a cooperation, the more is a collaboration, the more is assistance, more is information sharing. When there is a treaty, it binds a state to go by the provisions of the treaty. That is the purpose of this treaty. That is why I started by saying that entering into a treaty is a sovereign attribute, it is a sovereign power. So once a power is exercised, and once the power, by exercising this power, a treaty is signed, the state cannot shirk away from its responsibility by saying that, no, I will not extend the cooperation, I will not provide any assistance. They cannot say so because the treaty is a binding agreement, like any other agreement what we entered by adhering to the provisions of the Indian Contract Act. Here, we will adhere to the provisions of the public international law, and thereby, we will enter agreements with different jurisdictions. India provides mutual legal assistance in criminal matters through bilateral agreements and multilateral agreements or treaties or international conventions, or on the basis of assurance of the reciprocity. So, India will provide legal assistance to other jurisdictions on the basis of three major contours. One is the bilateral treaties, the second one is the multilateral treaties or international conventions, or on the basis of the assurance or the principle of reciprocity. Even in the absence of a treaty, if we adhere to the principle of reciprocity by saying that, okay, I'll honor you, you honor me, even though there is no treaty between both of us, on the basis of the reciprocity, on the basis of mutual consonance, we will extend the cooperation. That is also possible. India also adheres to that particular mechanism for extending cooperation or assistance in criminal matters. The mutual legal assistance then the next question that may arise, that may linger in our minds is, what is this mutual legal assistance in criminal matters? Okay, there are treaties, and the treaties provide for this mutual legal assistance. But what exactly the mutual legal assistance means? The mutual legal assistance treaties in criminal matters are the bilateral treaties, and they extend cooperation. The next question is the treaty, what it connotes. As I mentioned, when a treaty is entered, the treaty is binding. The treaty imposes an obligation, a mandatory obligation on the part of the state to share or to cooperate in criminal matters. So what the treaty is, it's essential to know what a treaty is. Treaty is an agreement where two or more states establish or seek to establish a relationship between themselves governed by the domestic national law and provide that it is intended to create a legal relationship. Treaty is nothing but a legal relationship between two sovereign states. Like the way we enter into a contract between two parties, it may be a commercial contract, it may be a private contract, it may be a personal contract, but a contract is between two parties by adhering to the principles of the Indian Contract Act. Similarly, treaty is an agreement, a contract between two sovereign states, and this contract will provide a legal relationship. The treaty means an international agreement concluded between the states in written form and governed by the international law, whether embodied in a single instrument or two or more related instruments, and whatever its particular designation. Whatever the nomenclature you call, if there is an agreement between the two sovereign states agreeing for some committed cooperation or committed arrangement, then it is called as a treaty. This definition is according to the Vienna Convention and law of the treaties. Friends, ladies and gentlemen, I would like to emphasize here one important aspect, that even to interpret a treaty, how a treaties are to be interpreted, there is a treaty for that. That's an important aspect you must realize when you start examining a mutual legal assistance treaty. If there is any deadlock, if there is any ambiguity in interpretation of that mutual legal assistance treaty, then you can take the recourse of this Vienna Convention on law of the treaties. This Vienna Convention, the law of the treaties, is to provide an insight information to us for the interpretation of the treaties. So according to this Vienna Convention on the law of the treaties, treaty means an international agreement concluded between the two states. course, India is not a signatory to this Vienna Convention, the law of the treaties, but this treaty can be interpreted by India on the basis of customary international law. The object of the treaty is to impose binding obligations on the states. That's what I mentioned. If there is a treaty, the state cannot deny your request. Say you send a request to a person residing to an authority in Singapore, asking to send a particular person or to transfer a particular person to Andhra Pradesh for his examination before the court of law in the state of Andhra Pradesh. As his witness, his statement is important to decide or to examine or to conclude a particular criminal case that is pending before you. It may be a serious case like a terrorist act, or it may be a serious case like cross-border cheating. It may be a case like cross-border dishonor of check issue, because I have examined several cases pertaining to cross-border dishonor of checks cases, particularly to UAE, United Arab Emirates, or Saudi Arabia, or Kuwait, where checks have been issued to a foreign player, and the checks were dishonored. So in that case, how to process this? How to get the particular person for examination? In that case, the person has to come and depose before the court that how the check issued got dishonored by the banks. So for that, you have to have transfer of that particular person. In ordinary sense, if you ask Singapore to transfer that person, or you ask UAE to transfer that person, if he is a national of that jurisdiction, naturally they may decline. Why should I send my national to a foreign jurisdiction, subjecting him to some court proceedings? So that mentality may enable them to deny or decline your request. But if you have a bilateral treaty, if you have a mutual legal assistance treaty, which imposes a binding obligation on the states who are parties to that, they cannot deny. If they deny, then you can drag them to an action by saying that it is a violation of the treaty commitment. I'll share some cases in due course of time where the parties have questioned the very provisions of the bilateral mutual legal assistance treaties. Once a state has bound itself by agreement in a treaty, it is not entitled to withdraw from its obligations without consent of the other states. So therefore, before signing any treaty, we double ensure that the treaty or the agreement what we are going to sign is in accordance with our national law. You cannot sign anything which is not in accordance with the national law. Suppose if a treaty provision, say for example, even the mutual legal assistance treaty, if some of the provisions are contradictory to our domestic provisions or national law provisions, then we will not sign. I'll share one example which I faced while dealing with this mutual legal assistance in criminal matters. It is particularly with reference to MLAT with Germany, mutual legal assistance treaty with Germany. Germany is a civil law country, and Germany, there is no death penalty. But in India, there is a death penalty. Of course, the death penalty is imposed on rare of the rarest cases. During the negotiations, there is an agreement on all the points, but there is a disagreement on a point that pertaining to this death penalty. Germany insisted that there shall be a provision in the MLAT that in case of death, in cases where the punishment is death sentence, India should assure and ensure that they will not impose a death penalty. That kind of a commitment they insisted from India during the negotiations. As a lawman, as a legal advisor to the government of India, I advised not to have such provisions in the treaty, because we cannot commit anything which is contrary to our legal position. How can you say that the punishment can be reduced to life imprisonment or some other form? It is a discretionary power of the court. Sentencing of a person is a discretionary power of the court, though we don't have specific statutory provision regarding sentencing of person, but there are inbuilt provisions within the statute with reference to the sentencing of a person. There are guidelines regarding sentencing of a person within the statute. The statute sometimes prescribes punishment of 5 years imprisonment or fine or both. That means the sentencing guideline is there within the statutory provision itself. So it is a discretionary power of the court. How can I commit that the death sentence can be reduced to a life imprisonment or some other form? So that is an example to quote that the treaties shall be within the domestic legal framework, and it cannot be beyond the legal framework of a nation. And treaty, once entered, it is binding on the part of a state. A state cannot decline or deny the assistance or cooperation once a treaty is entered. Now, the second question I would like to share with all of you is when we talk about the mutual legal assistance treaty, the question that may arise is whether there is any provision, whether there is any enabling statutory provision for entering into such treaties or not. As I mentioned, treaties are basically entered on the basis of an executive power of the state, which is conferred under Article 73 and 74 of the Indian Constitution. Indian Constitution confers power on the executive under 73 and 74. By exercising this executive power of the President of India enters into treaties with various jurisdictions. Like that, is there any provision under the law for enabling us to enter into this mutual legal assistance treaty? I also would like to share that even when a treaty is entered, sometimes we enact a law based upon the provisions of the treaty. And to enact a law based upon the provisions of the treaty, there is an entry in the Schedule 7, List 1 of the Indian Constitution. Schedule 7, List 1, Entry 13 and 14 enables the Parliament to enact a law on the basis of a treaty signed or to give effect to the provisions of a treaty. Like that, for giving effect to the provisions of the United Nations Convention Against Corruption, India has enacted the Prevention of the Corruption Act. India also enacted the Lokpal Act. India also made several provisions relating to corruption because India signed and ratified United Nations Convention Against the Corruption. So therefore, to give effect to that particular convention, particular law, there is a provision under the Constitution to enact a law. Like that, whether there is any provision, statutory provision to enter into this kind of mutual legal assistance treaties, the answer is yes. There is a provision both under the old CRPC, under the new CRPC, that is BNSS. Under the old CRPC, there is a provision called Section 109, which speaks about reciprocal arrangement, reciprocal agreements with reference to processes. So it elaborates that you can enter into a reciprocal arrangement on the basis of the provisions of Section 101 of the CRPC, old CRPC 1973. It clearly says that you can enter into bilateral mutual assistance treaties. Once you enter into a treaty, then the country with whom you had a treaty can be considered as a reciprocating territory once a treaty is notified, once a treaty is ratified by the government of India. Sometimes, even without this also, you can have an arrangement with a particular territory and you can notify that as a reciprocating territory by exercising your powers and by notifying that. This provision is there under Section 105 of the old CRPC. I'm not just going into each and every word of this section because all of you are aware that there is a provision under the old CRPC for entering into mutual legal assistance treaties with various jurisdictions. Now let us see what will be the provision or what is the provision under the new BNSS Act. You're all aware that CRPC has been replaced by a new enactment called BNSS, Bharatiya Nyaya Shiksha Smriti, and this new code, new criminal code, also containing a provision that is Section 110, that is 110. Of course, I must say that this is a kind of a replication of the old provision of 105 of the CRPC, but it also speaks about reciprocal arrangements regarding processes. So this new CRPC, the new BNSS, also facilitates, provides a provision for entering into mutual legal assistance treaties with various jurisdictions. So friends and ladies and gentlemen, please remind in the mind, keep it in mind that the mutual legal assistance treaties, what we are entering, what India is entering, is having a statutory basis, a statutory backup. So statutory provisions, as we just discussed, 105 of the old Act and 110 of the new Act. So when we enter into this mutual legal assistance treaty, whom should we approach? Who is the concerned person to approach about these MLAT issues? So you as a prosecutor or you as an investigating officer may have to send a letter to a person who is residing in a foreign jurisdiction. You may have to call a person as a witness or for examination before a court in Andhra Pradesh. Then whom should we approach? What is the mechanism? Who is the concerned person? And who is the concerned person authority deals with this mutual legal assistance matters? Friends, ladies and gentlemen, as per the allocation of the business rules of the government of India, I must say here that the government of India will function on the basis of allocation of business rules, because according to the General Clauses Act, the government of India means only the president of India. If you go to the definition of the government of India or the central government, it is only the president of India. President of India is the government of India. But president of India cannot alone discharge all the functions of the government of India. So therefore, president, by exercising his executive power under Article 73 and 74, allocated the business to various ministries and departments. That's how these various departments and ministries: Ministry of Law and Justice, Ministry of Corporate Affairs, Ministry of um, uh, Ministry of Finance, Ministry of Defense. All these are various various ministries to whom the business is allocated by the President of India. So as per this allocation, the concerned ministry, the concerned department, or the concerned authority is the Ministry of Home Affairs. So for all matters relating to mutual legal assistance in criminal matters, MLAT criminal, Ministry of Home Affairs is a nodal ministry and the central authority for seeking and providing mutual legal assistance in criminal matters. So whenever there is any issue before you, the concerned appropriate authority to whom you have to approach is the Ministry of Home Affairs. Ministry of Home Affairs receives all such requests, examines them, and takes appropriate action. You may ask me one question: why only Ministry of Home Affairs? Why can't it be Ministry of Law and Justice? Because it pertains to processing of a legal procedure. So why can't it be Law and Justice? Friends, ladies and gentlemen, law and justice is related to mutual legal assistance in civil matters, but in criminal matters, it has been assigned to Ministry of Home Affairs because the CRPC is administratively the subject concern of Ministry of Home Affairs. And apart from that, when you send a request, it also involves a question of security, the question of national interest, the question of sovereign interest. So whether your request can be processed, whether your request for mutual legal assistance from a foreign jurisdiction involves any threat to our nation, to our sovereignty, to our security, to our public peace and order, this will be examined by the Ministry of Home Affairs. That is why the MLAT subject has been assigned to the Ministry of Home Affairs. In the Ministry of Home Affairs, it is the Internal Security Division handles this subject in the Ministry of Home Affairs. Ministry of Home Affairs may be involved in this process when such requests are routed through diplomatic channels. Even if it has to be routed through diplomatic channels, Ministry of Home Affairs will forward. When you make a request to the Ministry of Home Affairs, say for example, for a transfer of a person from Malaysia, the request what you will be sending to the Ministry of Home Affairs will be forwarded to the Ministry of External Affairs. So two ministries play a very important role, because in Malaysia, where the person is located, the identity of the person, the address of the person can be better identified and located by Ministry of External Affairs through its mission located in Malaysia. Therefore, in the process of MLAT, Ministry of Home Affairs, Ministry of External Affairs play a pivotal role. But the concerned administrative ministry for mutual legal assistance is the Ministry of Home Affairs. So that you must keep in mind. And what is the procedure? What is the procedure to be followed? We'll see the procedure in case of bailable warrant, in case of non-bailable warrant. First, let us see what is the procedure in case of mutual legal assistance in cases pertaining to a bailable warrant issued by the courts. The summons and the warrants of the judicial process that is received by the Ministry of Home Affairs are forwarded to the concerned Indian mission. So once the matter is forwarded to the Ministry of Home Affairs, the Ministry of Home Affairs will further forward it to the concerned Indian mission or embassy, which in turn takes up the matter with the designated central authority. Remember, the mutual legal assistance is through the central authority of India and the central authority of the other jurisdiction. As I mentioned, the central authority in India is the Ministry of Home Affairs. That is the central authority. So when you send a request to the Ministry of Home Affairs, the Ministry of Home Affairs will further forward it to the concerned mission or embassy, which in turn take up the matter with the designated central authority in that country. If it is Malaysia, once you send that notice to the Ministry of Home Affairs, Ministry of Home Affairs will forward it to the mission in Malaysia, And the mission in Malaysia will contact the central authority of the Malaysia under the Mutual Legal Assistance Treaty. In the Mutual Legal Assistance Treaty, we will be notifying, we will be identifying who is the central authority. Even under the MLAT, we will identify Ministry of Home Affairs as a central authority. In case of MLAT countries, the manner and communication is also laid down in the MLAT. So how do you communicate, whether it should be in the form of an email, whether it should be in the form of a WhatsApp message, or whether it should be in the form of an official communication, or whether it shall be in the form of a format prescribed under the MLAT. That is up to the states. You can prescribe a format under the MLAT on which you can send the request for processing the things under the Mutual Legal Assistance Treaty. The designated authority, after considering the request, directs its agency to serve the documents on the concerned person and report the service if he is also received through the same channel. This is broadly the system in most of the countries. Most of the countries will follow this system, and India, all requests for service of summons, notices, judicial process on persons residing abroad should be addressed to the Undersecretary, Legal, IS2 Division, Ministry of Home Affairs, 9th floor, Lokanayak Bhavan, New Delhi. So this is the address to whom you should send or whom you should forward the request for mutual legal assistance under a treaty. But remember, friends, this is only in case of a bailable offense. So what will happen in case of a non-bailable offense? The procedure in case of non-bailable offense. Yes?
Sir, మళ్ళీ ఒకసారి అడ్రస్ చెప్పరా?
The address is it is the Undersecretary Legal IS2 Division, Ministry of Home Affairs, 9th floor, Lokanayak Bhavan, New Delhi, 11003. He is a concerned person relating to mutual legal assistance in criminal matters. Remember, where a bailable warrant is issued by the Indian courts.
చూడమ్మా, అడ్రస్లు క్వశ్చన్లు చివర్లో అడుగుదాం. సార్ని చెప్పనేయండి. మీకు అడ్రస్లు కావాలంటే డైరెక్టరేట్ లో ఉంటాయి అన్ని. ఫస్ట్ లెట్ ఇట్ కంప్లీటెడ్, తర్వాత చివర టైం ఇస్తారా, టైంలో అడగచ్చు. డోంట్ డిస్టర్బ్.
Now, in case, no issue, sir. In case of non-bailable cases, so what is the procedure in case of non-bailable cases? In case of non-bailable cases, the Ministry of Home Affairs does not undertake service of non-bailable warrants of arrest. They will not undertake any non-bailable cases or warrant in case of non-bailable. The service of non-bailable arrest warrants amounts to extradition of the individual. So the reason why the Ministry of Home Affairs will not entertain any kind of notice in case of non-bailable offenses. It entertains only the notices in case of bailable offenses, because in case of non-bailable arrest warrant, it amounts to extradition of a person. Request for extradition, then you may ask me one question, sir, how to get that individual in case of non-bailable offenses where arrest warrant is issued? For that, you have to approach, you have to follow a different mechanism for mutual assistance. That different mechanism for mutual legal assistance is extradition. So requests for extraditions are based on legal principles and procedure contained in extradition treaties negotiated with foreign countries, and such requests are to be forwarded in the prescribed format to the Ministry of External Affairs, CP Division, Patiala House, Annex C, Tilak Marg, New Delhi. So as mentioned, in case of mutual legal assistance criminal, the Home Ministry is the concerned administrative department. In case of extradition and transfer of sentenced persons, it is the Ministry of External Affairs, because as per the allocation of business rules, extradition has been assigned to the Ministry of External Affairs. Why? Because extradition pertains to a person residing in a foreign territory. We will not have access to the foreign jurisdiction, but our Foreign Affairs Ministry, that is Ministry of External Affairs, will have access to all the jurisdictions of the world, because our missions are there in every jurisdiction of the world. In that, through that mission, they will process the things. That is why, in case of extradition, it is Ministry of External Affairs. I will also explain what extradition is and how it is different from mutual legal assistance in criminal matters. In criminal, mutual legal assistance treaties will not facilitate any extradition process. Suppose if you ask extradition of Vijay Mallya under the MLAT between India and UK, the UK may not accept your request. You may straight away decline your request, saying that MLAT does not facilitate, does not provide for extradition. For extradition, you have to enter into a separate treaty, which is entirely different from mutual legal assistance treaty. And the list of the countries with whom India entered into mutual legal assistance treaty for your perusal. As I mentioned, we entered into 42 countries with whom we are having mutual legal assistance treaty. These are the countries with whom we had this kind of an arrangement. I thought of sharing these details with all of you for your kind perusal and consideration, for using the same at the appropriate time while discharging your day-to-day functions, because you play a very important role in the criminal justice administration system. You are the officer of the court. You will assist the court. You facilitate the court to enable it to perform its functions smoothly and to do justice to the all. Because we are based on the principle: let 1,000 criminals escape, but one innocent should not be punished. So that is the basis on which we conduct the entire criminal justice administration system. So this may be useful for you to use it the same at the appropriate time. I must say one point here is that the MLAT with the Kingdom of Morocco, though it is signed, it is yet to be notified, because there are two aspects, friends and ladies and gentlemen. Signing of a treaty is different from notifying a treaty. Unless India notifies the treaty, unless India ratifies the treaty will not come into force. There are several such treaties India signed, but India is yet to notify, yet to ratify the same. For example, in the 2019, in the year 2019, India signed the United Nations Convention on Mediation, which we call as UNISA. But India is yet to ratify this convention. Like that, with Kingdom of Morocco, we are having an MLAT, but we are yet to ratify that particular MLAT. But with other countries, remaining 42 countries, we have notified, and we have provisions to access the information or assistance under these treaties. So this is a picture about the MLATs that India signed with different jurisdictions. Now coming to the heart of our discussion, the key point of our discussion: what is the scope of this MLAT? Why should we have this MLAT? What is the scope of this MLAT? Because the topic that is assigned to me is about the challenges and the benefits and challenges of the MLAT. No doubt, MLAT has some benefits. At the same time, MLAT also poses some challenges, which we will discuss in due course. Now, let us see what is the scope of this MLAT. What is the object of this MLAT? The mutual legal assistance is any assistance given by the requested state. Friends and ladies and gentlemen, here the state, the country which makes the request is called as a requested state. And the country to whom you are making request is called as requesting state and requested state. Say India is requesting the Singapore, then India is a requesting state and Singapore is a requested state. To whom you are making the request is called as a requested state, and who is making a request is called as a requesting state, irrespective of whether the assistance is sought or is to be provided by a court or some authority, and shall include. Remember, in case of MLAT, you don't require even a court order as such. Without court order also, you can ask for such cooperation and such coordination. That is the advantage of this MLAT. So that is how the scope. Remember, this scope will be provided in the treaty itself. In the agreement itself, the scope will be provided. I am just sharing the general scope, which is incorporated in all the MLATs that we have signed so far. That is all the 42 MLATs which I referred you before in my previous slide will have the same scope. The scope is maybe some here and there, some changes may be there according to some language or according to the country with whom you are negotiating. Sometimes there may be translation issues also, because all the countries are not English speaking countries. So some countries may have a language problem while translating this into their own language, and thereby they may make some changes in the language, speaking with language, but the scope will remain the same. The basic scope of this MLAT is locating and identifying a person and objects. Even if an object is located in a foreign territory, you can ask for assistance and cooperation on that. Say, for example, the property which is in dispute before an Indian court is located in a foreign jurisdiction, then you can ask for the object. Service of summons and other judicial documents is another area where you can have a cooperation and assistance. Taking of evidence, as I mentioned, you can ask for transfer of a person for taking of evidence, obtaining testimony from persons, including expert examination. Expert examination is required in case of some issues. For example, when there is a incident of a terrorist attack at Mumbai, where several people are brutally killed by terrorist activities, say especially the Taj and other things, where we had expert examination. A committee was formed, a team was formed, and the expert team visited Pakistan, and the people came from other jurisdictions like UK and USA for depositing before the courts. So taking evidence, obtaining testimony from persons, including experts, executing inspection and search and seizure. Friends and ladies and gentlemen, I must say about this executing an inspection and search and seizure. In case of Antrix Devas, by exercising the provisions of the Mutual Legal Assistance Treaty between India and Singapore, the government of India, the CBI and the other investigating agencies, CBI and ED, asked for executing an inspection, search and seizure in case of Singapore pertaining to some persons, some of the stakeholders or the equity holders of Devas Multimedia Company, which is involved in this. I'll explain what this Devas and Antrix case in due course to enable you to examine, and I appreciate the provisions of the MLAT and the importance of this MLAT. And providing material and documentary evidence. Suppose if you feel that some material or some documentary evidence is there in a foreign jurisdiction, you can ask for that. Making persons in custody and others, including experts, available to give evidence or assist in investigations. Location, restraining, seizure and confiscation of the proceeds and instruments of crime, providing relevant judicial records and exchange of legal information, other forms of legal assistance. Suppose if there is some judicial record available with you, that can be asked by your counterpart in US or your counterpart in Germany or your counterpart in UK. That is a sharing of information. So this is the scope of mutual legal assistance treaties in criminal matters. If you have an MLAT, you can have all these opportunities. You see how wide the scope of the MLAT is. It is just almost having access to every aspect of the criminal case. It will play an important role in criminal justice administration. It will enable you to solve the case before the court. So this is the scope of the MLAT. Now, what is excluded from the MLAT? I explained you what is covered under the MLAT. Now we'll see what is not covered under the MLAT. So when you send a request for mutual legal assistance, you must ensure that it is not an exclusion under the MLAT. You must ensure that it is an inclusion under the MLAT. If it is an exclusion under the MLAT, then no cooperation can be extended under the MLAT. What is excluded under the MLAT? Assistance under the MLAT shall not include extradition. As I mentioned, extradition is an exemption under the Mutual Legal Assistance Treaty, and detention of a person with a view to extradite that person. So extradition is not possible. Detention of a person for extradition is also not possible. Enforcement of criminal judgments rendered by the courts of the requesting state on the territory of the requested state is not possible. For example, if there is a judgment delivered by the Andhra Pradesh High Court, you cannot ask the Singapore counterpart to execute your judgment in Singapore because there is a territorial limitation. So that is not possible. Transfer of person in custody to serve sentences. If the person is already in the custody, undergoing some sentence, he cannot be transferred, and that can be an exclusion. Transfer of proceedings in criminal matters. You cannot ask transfer of criminal proceedings from one case to another case. I draw your attention. I hope all of you might have heard about the Italian mariners case. I hope you are. A ship from Italy entered into our territorial waters, or even when it is on the high sea, there was some firing by the mariners, which killed 2 fishermen in India, the Kerala. Now the question here is about the proceedings in India and the proceedings in Italy. Italy may also communicate the proceedings because their law, they may have jurisdiction, like the way we have jurisdiction under our IPC, which speaks about the extraterritorial jurisdiction. And during our college days, Mr. Koteswara used to elaborate all these points very eloquently. So extraterritorial jurisdiction, when an Indian commits an offense and a foreign vessel or a foreign territory, he may be subject to the Indian law because he is an Indian. So like that, there may be a jurisdictional issues on this point. So transfer of persons in criminal matters is an important issue. In this particular case, the Italian mariners filed a case questioning the jurisdiction of the Indian courts, saying that the Indian courts do not have the jurisdiction, and therefore, as per the United Nations Convention on the Law of the Sea, their case must be transferred to Italy, that is under the UNCLOS, or it may be transferred to the UNCLOS tribunal, that is United Nations Convention on the Law of the Sea tribunal, and ultimately the case was decided accordingly. Yes, madam. So exclusion is transfer of proceedings in criminal matters is an important aspect under the MLAT. At the same time, you may ask me one question, sir. When an MLAT is signed, does it mean that we are compulsory and bound to give the information or bound to cooperate every time or all times, compromising our national security or national interest? The answer is no. Even if you enter into a treaty, sometimes you can refuse the cooperation. When you can refuse the cooperation, you can refuse the cooperation, you can refuse the assistance if you feel that the request will impair your sovereignty, your security, your public order, or other essential public interest, then you can refuse the request. Suppose India made a request to Singapore. If Singapore feels that accepting India's request may impair their sovereignty, may be a threat to their security, may be a threat to their public order or the essential public interest, Singapore can refuse to extend the assistance, even though there is a binding commitment or binding obligation, because we will incorporate all these provisions in the treaty itself. What to be considered, what not to be considered, everything will be given in the Mutual Legal Assistance Treaty. And the second part where you can refuse is that when you believe that the request for assistance has been made for the purpose of prosecuting a person on account that the person's race, sex, religion, nationality, or ethnic origin, expression of the opinion, or that the person's position may be prejudiced for any reasons. Suppose if you want to target any particular person by means of his race, sex, religion, nationality, and ethnic, and then that can be refused. But all these, friends and ladies and gentlemen, are subject to the proof. They have to establish, they have to give reasons for that refusal, not just simply declining that I'm sorry, I will not extend the cooperation. They have to come up with the reason. And the request relates to an offense in respect of which the accused person has been finally acquitted. Suppose if the person is finally acquitted in that particular jurisdiction, then they can refuse. But before refusing the assistance, or you can postpone the legal assistance. You can postpone the legal assistance where it interferes with an ongoing investigation or prosecution in the requested state. But before you refuse a request or before you postpone the execution of a request, you shall consider whether assistance may be provided subject to such conditions or not. Because you have a commitment, you have an obligation under a treaty. So before you refuse, you must consider yourself, can I accommodate the request made by India or not? If you feel that it cannot be accommodated for the reasons 1, 2, 3, 4, then you can decline the assistance. But that assistance declination or that refusal has to be communicated to the requested state, that is India, if India is the requested state. And service of documents, how the documents can be serviced under the mutual legal assistance treaties. The requested state shall serve any document transmitted to it for the purpose of service, and the requested state shall transmit each request for the service of a document pertaining to a response or appearance in the requesting state within a reasonable time. Friends, ladies and gentlemen, remember, time is the essence of request. You must make a request within the reasonable time, not at a belated stage. Say, for example, a case is filed 3 years back, and after 5 years, you are sending a request. Your request can be declined by the other state. So you must send the request clearly and the purpose for which the request is made. The requested state shall return a proof of service. You also should enclose a written proof of service in the manner required by the requesting state. If the service cannot be effected, the reasons shall be communicated immediately to the requesting state. If it is not feasible, immediately you have to send the same with reasons to the requesting state. This is another advantage of having mutual legal assistance. In addition to getting assistance and transfer of the documents, there is another important feature of the MLAT is transfer of persons in custody to give evidence or to assist in investigations or criminal proceedings. Suppose if you feel strongly as an investigating officer or as a prosecutor that a particular person who is residing in, say, United States is an important witness or an important expert or an important person to give evidence before the court or to assist you in investigation or assist in criminal proceedings, you can ask for transfer of that person. But the request shall be made very clearly, unambiguously, and indicating the case in which his assistance is required, in the case in which he has to depose as a witness, in which he has to give an evidence, has to be clearly indicated. Once you make a request, if a person is transferred to you, then you are having an obligation to provide utmost security and custody to that person. The life and liberty. That's why I started with a slide that providing life and liberty, protecting the life and liberty is an action, is a duty of the state. It is a duty of the state to provide protection, life and liberty. Security is a duty of the state. That's why we are all here. The prosecutors, the police officers, the investigating agencies, all are here to protect the life and liberty of the people. So when a person is transferred to you for examination or assisting in investigation in criminal proceedings, you owe a duty to protect him when he was in your custody. When he was in custody, you have to protect him. Once the task is completed, once the investigation is completed or evidence is completed, then you have to return him. His presence is no more required, you have to return him. But once, till that time, it is a duty of the state to protect him, and it is a duty of the state to return him or release him once the purpose is completed. So safe custody of the person transferred for evidence is a primary obligation, the primary duty of the state. A person present in the requesting state pursuant to request seeking that person's attendance shall not be detained, prosecuted, or subject to any other restriction of personal liberty. You cannot subject him to any prosecution. You cannot subject him to any other restriction once he is transferred to you for some particular purpose as requested under the Mutual Legal Assistance Treaty. That person shall not, without his consent, even you cannot compel him to give evidence in any proceedings, because it is our fundamental law. No person shall be compelled to be witness against himself. You cannot ask me that you please confess that you did this and you committed this murder. So that is what the basic principle or fundamental principle on the basis of which the whole criminal justice administration is built. So the person shall not, without his consent, be required to give evidence in any proceedings or assist in any investigation. The protection will come to an end once the mission is accomplished, once the examination is completed, once the investigation is completed, or after 30 days of his expiry of the 30 days, whichever is earlier, and he cannot stay here. You have to transfer him to his jurisdiction. This is the obligation under the MLAT, that is safe custody of the person. So when you ask for transfer of a person for evidence, you also owe a responsibility. If something happens to that person, you will be held liable. The responsibility will be fixed. It comes under the state responsibility under the public international law principle. And the state has to pay a huge compensation for that if something goes wrong, if an incident happens during the custody of the person transferred under the Mutual Legal Assistance Treaty. And now, apart from this transfer of persons and assistance and processing of the documents, you can also ask information on judgments. Suppose if you feel that there is a judgment.
Sir, one submission.
Yes, please. You please intervene
Sir,
as and when you have some issue. Yeah.
PowerPoint presentation full screen pattern, sir. Yeah.
Full screen. Okay, 1 second. Screen. Now it's okay? No.
Okay, sir.
Okay. So it's not just providing assistance or transfer of person. It is also information on judgments. You can ask information on judgment. Suppose if you feel that there is a particular judgment delivered by the UK Supreme Court, which will have a relevance on your investigation, which will have a relevance on your case that is pending before a criminal court, you can ask the details of the judgment, or you can ask extracts of the judgment under the MLAT. Then you can provide that judgment, the details of the judgment. It happened. Several cases are decided on the basis of inferences taken from the foreign jurisdictions or foreign courts, especially when it pertains to. You may ask me one question, sir. Why should we ask? What is the relevancy of the foreign court judgment or judgments in other states? Because judicial records, how it is relevant. See, suppose if there are cases where there may be cross-cutting issues, similar cases might be pending against the same accused in other jurisdictions. Then the records or the documents that have been examined or considered for the judgment may be relevant to you in your case, in your matter before the court. So therefore, information on judgments can also be sought under the MLAT. That is also very, very important. In fact, we sought information from various courts on this point in this regard. Now, apart from this, the major important aspect of the MLAT is proceeds and instruments of crime. How to get the proceeds of the crime? The proceeds of crime plays an important role in cases where money laundering is involved, because all of you are aware that money laundering is closely connected with the proceeds of the crime, because money laundering is linked with the predicate offense provided under the Money Laundering Act. The schedule of the Money Laundering Act elaborates various offenses under the different enactments. So to prove money laundering, prima facie, it has to be proved by the prosecutor concerned that yes, it is an offense committed under this, and the proceeds of that offense are used for this purpose. Then only a case can be filed under section 3 and 5 of the Money Laundering Act. So proceeds of crime a very important role in case of money laundering and corruption matters, and the proceeds of crime and instruments of the crime can be accessed through this mutual legal assistance treaty. Under this, the requested state shall upon request endeavor to ascertain whether any proceeds or instruments of crime are located within its jurisdiction and shall notify the requesting state. Suppose the proceeds of crime, say for example the case of Vijay Mallya, why we are asking the extradition of Vijay Mallya and why we are asking assistance in this regard. Suppose if you feel that Vijay Mallya kept the proceeds of the crime what he committed in India, say in UK, we can ask the UK government, the UK Central Authority under the MLAT, to identify the assets that are located in UK and inform India. Once the information is given, then India can ask for transfer of those proceeds, access to the proceeds. This is what we are seriously struggling and trying for under the prevention of corruption, under the United Nations Convention of Corruption against the United Nations Convention against the Corruption. This also we are doing it under the UN ODC office, asking them to return that proceeds to India, the money that has been accrued, the proceeds of crime by means of fraud and corruption. Because by means of fraud and corruption, the proceeds are taken to a foreign territory. If the money is lying there, then we can ask for the instrument and the proceeds. The requested state shall upon request take the necessary provisional measures such as freezing or seizing. When a request is made, the requested state will freeze that property or the proceeds and will return it to the concerned requested state, requesting state for its confiscation and for the necessary action. So proceeds and instruments of a crime can be accessed under the mutual legal assistance. But all these measures, whether it is confiscation, freezing, seizing, or preventing any dealing with that proceeds of the crime, all these are subject to national laws or domestic law of the country. That is why every country will have law according to the convention, what they sign, what they accept or ratify. So United Nations Convention against the Corruption is almost all signed by more than 165 countries. So almost all the countries have the law relating to that. Money laundering has been signed by majority of the members of the world. And majority of the members of the world are also members of the FATF, Financial Action Task Force, which is a instrumental authority internationally for all these global corruption and proceeds of crime is concerned. And of course, similarly, we too have an FIU, Financial Intelligence Unit in India. The FATF will transfer that information to FIU. FIU will transfer further to all the investigating agencies like you and the CBI and NIA and ED. They will make further investigation. This is how the whole chain will process whenever there is any request relating to proceeds and instruments of crime. It is not just always India requesting for proceeds and instruments. Even requests can be received from other jurisdictions also. England can ask, UK can ask India for this assistance, and in such case, Indian agencies also will look into that, will examine that, and will freeze and seize that account if required. This is what the benefit we'll have under the mutual legal assistance and treaty. And apart from that, search and seizure is also another important. You can be a part of the search and seizure if you desire so, along with their team, provided it all depends upon the facts and circumstances of the case. But not that in every case it should be allowed or encouraged. So the requested shall execute a request for search and seizure. Search and seizure shall be conducted by the requested state to the same extent under the same conditions has to be got done for its own law. So what are the terms and conditions? What is the procedure mechanism you follow under your law? Same has to be followed. You cannot deviate from that. You cannot ask beyond what is permitted under your domestic legislation. As I mentioned in my introductory words, recently, with reference to this Antrix Devas case, we have requested the Singapore authorities for search and seizure and asking them to allow our investigating agencies also to be part of their agencies or to have interaction with their agencies. That has been facilitated. Our investigating agencies like ED and CBI, they had been to Singapore. They have some common search and seizure examination of the issues. So this is the advantage of the mutual legal assistance treaty. If you feel that a search and seizure is important and necessary for you, you can also request for the search and seizure. They will submit a report also. The report can be filed before the court. Court will take note of that report because it is pursuant to a mutual legal assistance treaty which has been entered and executed in view of the provisions of the CRPC. So the court cannot turn a blind eye and cannot brush aside saying that, no, I'm sorry. The court cannot say duff air saying that I'm sorry, I cannot consider this because it is a binding obligation. It is a sovereign treaty signed between the two countries and it is pursuant to the treaty action is taken. So therefore, courts are bound to consider the same. Courts cannot say that I will not look into this, I will not consider this. And the second, the another advantage of the thing, these are the advantages. And now we'll see how a request shall be made. What should be the content of the this request? What your request should contain request for legal assistance. Your request for legal assistance, whenever you make a request for legal assistance, keep in mind all these points that you must ensure that all these points are duly confirmed or duly ensured. Because if you are not ensuring these contents, there is every possibility of turning down your request, rejecting your request. It happened to us even in the same Antrix Devas case. When the request is made to the US authorities for assistance in some issues, because some of the major key witnesses pertaining to this Antrix Devas, because the whole Antrix Devas case is relating to fraud and corruption. I'll explain you this after completion of this contents of this mutual legal assistance. It's a very classic case of fraud and corruption. You must all know how fraud can be done at the state exchequer, or it's a public fraud. It's a fraud at the face of the public. That's what Justice Ram Subramaniam commented while examining this case by the Supreme Court. So here we made a request to the US authorities, but the US authorities turned on saying that the legal assistance request is lacking some issues. So they sought further clarification or further fresh application from the authorities or agencies concerned. So therefore, you must ensure that your request fulfill all these obligations or all these contours of a request. One, the description of the competent authorities responsible for conducting the investigation. So you have to give description of the officer, competent authority, who is making the investigation or the court proceedings to which the request relates. The request must relate either to the competent authority conducting the investigation or the court proceedings. You can say that these court proceedings are pending, therefore this assistance is required. Or this investigating agency or this investigating authority is conducting an investigation, therefore this assistance is required. The second one is the purpose of the request and the brief description of the assistance sought. So what assistance you want, what is the purpose of your request, that should be clearly mentioned unambiguously. You must give clear description of the assistance sought. Description of the facts alleged to constitute the offense. So what facts constitute the offense? Not just giving the facts that constitute an offense. It's a statement or text of relevant laws. You have to support it, substantiate it with the support of the relevant laws, except in cases of request for service of documents. In case of service of documents, you need not establish, you need not explain the description of the facts and other things. And any other information necessary for execution of the request, in particular information concerning the identity of the persons concerned in the request. So identity of the person, if any information you would like to provide regarding identity of the person, you please provide. Friends, ladies and gentlemen, some of the issues, some of the problems relating to the MLAT is an identity of a person, because it is sometimes persons may have duplicate passports. They can have a different passport and they survive in another jurisdiction with a different name and a different identity. Then how do you match? You send that X son of Y is residing in Bangkok. Please transfer him for examination. Then the competent authority of the Bangkok will go and examine. He will say, I am not X, I am XY, son of YZ. The name is changed, the passport is different. Then how do you identify? Recently, we got a reference from the US authorities. You might have heard about this illegal immigration of people into US. Of course, there are several Indians also illegally immigrated into India. Illegal immigration is a very serious, heinous crime under the US law. It's unlike India, it's a very serious and stringent action will be taken. So what they did is, what they offered us is that they asked us to share the biometric information of the people, because there is an identity crisis. There is an identity crisis. We said that biometric information is a very serious personal, digitally secured information of a person. It's a personal identity. Your fingerprints, your iris, all these are biometric information, which we collect at the time of issuing of a passport, or even at the time of issuing of your Aadhaar card. That's why the question of Puttaswamy and other things which arose before the Supreme Court of India about the data protection and whether the personal data is related to the privacy of a person or not, where the Supreme Court held that yes, it relates to privacy. So therefore, we said that this information cannot be shared except for security purposes. Only for security purpose. Suppose if it is a national security, national threat, there are some terrorist activities, then we will share the information. Otherwise, we will not share the information. So identity of a person, I'm just sharing this about the identity of the person, because if you have this identity, then it is easy. I can nab him that even though you have a duplicate passport, your biometric information is confirming that you are Mr. X, therefore nothing doing, come to the case. This we have done in another case where a request has been accepted and the information has been shared through national investigating agencies pertaining to a terrorist activity case. So for security purpose, we will share, but other than that, we will not share the personal biometric information. Therefore, you must be very clear about the identity of a person and the details of any particular procedure, requirements. If you have any particular procedure, suppose if you want the witness or the examination of a document in a particular format, you ask a confirmation from a US forensic department asking whether this document has been executed in a foreign territory or not. They will examine it from forensic angle. And if you have any particular format, particular procedure to be followed in that regard, you can make that request also. If necessary, specification of any timeline. Timelines are very, very important, because sometimes you may get delayed the information from the foreign territory. And the delay will vitiate your case before the criminal court. How long will the criminal court wait for you to get the information? There are several cases where the Delhi High Court and even the Supreme Court has dismissed the petitions on the ground that we cannot sit long years for the sake of information which is to be obtained or which is to be received from a foreign territory under the MLAT. Sometimes they may take years together. In Antrix Devas, we are waiting for years. Since 2016, we are struggling with this issue and we are pursuing with all the concerned agencies to get the appropriate information. So nabbing a person will be very difficult in some situations, even though you are the best, having the best intelligence and you are having the best enforcing agencies with you. Because the criminals have their own mindset, they have their own network of escaping. There are several corroborated criminals who will help them to escape. So therefore, sometimes time is an important aspect. So time frame also need to be informed. In case request to take evidence from a person, the request shall contain information about the subject matter. Suppose if you want to have the request for examination of a person, that is transfer of a person for examination, then you must give the subject matter of that evidence, why that evidence is required, and what is the importance of this evidence that you have to mention in your request. So friends, ladies and gentlemen, please follow these points very carefully when you want to process a request under the MLAT with any foreign jurisdiction. Whatever may be the MLAT with the country, it may be UK, US, Romania, Italy, France, Germany, Japan. These are the contents of the MLAT. I'm just giving you the broad contents. I'm not taking any one particular MLAT as a case study, but I'm giving you the general contents of this MLAT. You may find these kind of MLATs, these kind of provisions in almost all the MLATs. Another important aspect which need to be considered about this MLATs is the principle of confidentiality. All the information you share or all the information you get under the MLAT is confidential. The requester shall upon request keep confidential the request for assistance, its contents, and the supporting documents, as well as the fact of the granting of such assistance. If the request cannot be executed without breach of confidentiality, the requester shall inform the requesting state, which shall then determine whether the request should nevertheless be executed or not. Suppose if it's not possible for you to maintain confidentiality, as it is impossible to maintain confidentiality or confidentiality cannot be maintained, then you must inform the requested state that confidentiality can be compromised. Then in such case, the requested state will take a decision whether to provide information or not, because confidentiality is very, very important and you must ensure the information shall be confidential. It is requested state shall upon request keep confidential the evidence and the information provided by the requesting state, except to the extent that the evidence and information is needed for the investigation and proceedings described in the request. So you can use it only for the purpose of your investigation or your proceedings you mention in the request. Other than that, you cannot use this information for any other purpose. Though you got information in one case, you cannot use it in another case without intimation or permission from the requested state. That is why important aspect is to be considered is confidentiality. Practical case which we examined, which I examined in my official capacity while dealing with a case relating to
జోగర్ గారు మీ వాయిస్ లాస్ట్ అయిందండి.
Unable to
జోగారా గారు మీ వాయిస్ లాస్ట్ అయింది. జోగారా గారు
నెంబర్ వచ్చి 92/23.
ఢిల్లీలోనే బ్రేక్ అయ్యాడు. ఈ ఇష్యూస్ ఉంటాయి, నెట్వర్క్ ఇష్యూస్. కదా పీపుల్ క్యాచ్ చేసుకున్నాడు అంటే ఇద్దరు జేడీలు క్యాంపులేగా కేసులకు వెళ్ళిపోతున్నారుగా. ఏమాట పెద్ద హాలీవుడ్ గురించి పెద్ద దేనికి పనికి రానాడు. రాజశేఖర్ గారు, ఇప్పుడు మనకి ట్రీటీస్ గురించి కంప్లీట్ అవగాహన రావాలంటే ముందర మనకి పాస్పోర్ట్ యాక్ట్ మీద, ఫారినర్స్ యాక్ట్ మీద, ఇమిగ్రేషన్ యాక్ట్ మీద, సెక్షన్ 105 సిఆర్పిసి మీద, ముందర వీటి మీద ఒక బేసిక్ అవేర్నెస్ ఉండాలి. రాజశేఖర్ గారు వినిపిస్తుందండి?
సార్ వినిపిస్తుంది సార్.
ఇప్పుడు మనకి ఈ ట్రీటీస్ గురించి అర్థం అవ్వాలి, ఇంకా కంప్లీట్ థరో నాలెడ్జ్ రావాలి అంటే ముందర మనకి
105 చూసుకోవాలి.
105 చూడాలా, ఫారినర్స్ యాక్ట్ చూడాలా. మీ ఇద్దరే ఎక్స్పర్ట్లా 360 మంది ఉన్నారు, మాట్లాడితే అందరితో మాట్లాడండి. మీ ఇద్దరు రాజశేఖరు నువ్వేనా ఎక్స్పర్ట్లు అంట. సార్ మాట్లాడితే అందరితో మాట్లాడండి. మీ ఇద్దరే మాట్లాడుకోవడానికి మీ ఇద్దరు ఫోన్ కాదు కదా ఇది. ప్రైవేట్, ఇట్స్ నాట్ ఏ ప్రైవేట్ ఇంటరాక్షన్. If you want to speak, speak with all of the prosecutors.
గుడ్ మార్నింగ్ సార్.
గుడ్ మార్నింగ్, చెప్పండి.
సార్ పవర్ పాయింట్ ప్రెజెంటేషన్ చాలా బాగుంది సార్. ఈ పవర్ పాయింట్ ప్రెజెంటేషన్ వాట్సాప్లో పెడితే అది ప్రింట్ తీసుకొని పెట్టుకుంటే ఎప్పటికైనా చాలా బాగా పనికొస్తుంది సార్.
ఇద్దాం అని సార్ వచ్చినాక అయిపోయినాక ఇప్పిద్దాం, దానికే పెద్ద ప్రాబ్లం లేదు. విల్ గివ్ ఇట్
సార్. థ్యాంక్ యూ సార్.
తప్పకుండా.
భర్త కూడా చేయండి.
ఐదు నిమిషాలు ఫోన్ చేస్తున్నా.
సార్ ఏమి వినపట్లేదు సార్.
ఏమంటే కనెక్షన్ లాస్ట్ అని మీకే కాదు మాకు కూడా ఇబ్బంది. సార్ కనెక్షన్ లాస్ అయింది స్పీకర్ గారిది. ఒక 5 నిమిషాలు వెయిట్ చేయండి, వస్తారు చూద్దాం.
సార్ చిన్న డౌట్ ఉంది, అడిగినా సార్.
అడగండి.
సార్ ఇప్పుడు ఈ 41A నోటీసు వాట్సాప్ లో ఇస్తే కుదరదని అంటున్నారు సార్. దానికి ఏమైనా రెమెడీ ఏమైనా ఉందా సార్? కొంతమంది అబ్రాడ్ లో ఉంటున్నారు సార్, వాళ్ళకి మనం తప్పనిసరి పరిస్థితుల్లో 41A CRPC నోటీసు వాళ్ళ యొక్క వాట్సాప్ ద్వారా సర్వ్ చేయాల్సిన పరిస్థితులు వస్తున్నాయి సార్. ఇలాంటి సందర్భాల్లో మాకు వే అవుట్ ఏంటో తమరు చెప్తే కొంచెం దాన్ని బట్టి ముందుకెళ్తాం సార్.
చెప్పండి, చాలా మంది సీనియర్ ప్రాసిక్యూటర్లు ఉన్నారు, చెప్పండి వాళ్ళని. ఆయన ఎస్ఐ గారికి వే అవుట్, ఎస్ఐ గారు సిఐ గారికి వే అవుట్ చెప్పండి. ఏంటి మరి ఆయన డిబేటబుల్ పాయింట్ అడిగారు, మీ సమాధానం ఏంటండి? డిస్కస్ చేయండి. ఇందాక పొద్దున్న లేచిన కానీ గుడ్ మార్నింగ్ పెట్టేటప్పుడు ఆయన డిబేటబుల్ పాయింట్ పెట్టి మాట్లాడండి అందరూ.
సార్ నమస్తే సార్.
చెప్పండి
సార్. 105 CRPC కింద మనం ఇక్కడ వెయ్యొచ్చు. మెజిస్ట్రేట్ కోర్టులోని NBW కానీ బెయిలబుల్ వారెంట్ కానీ ఉంటే నేను ఒక్కసారి ఇది ఫేస్ చేశాను. అయితే అఫ్ కోర్స్ నేను ఫెయిల్ అయ్యాను అందులోని. ఏంటనంటే అది 498A 3 and 4 ఆఫ్ DP యాక్ట్ ప్రకారం నేను వేశాను. సంవత్సరం వరకు ఒక మెజిస్ట్రేట్ గారు దాన్ని చాలా లేట్ చేశారు. ఆ తర్వాత నెక్స్ట్ మెజిస్ట్రేట్ గారు వచ్చారు, ఆవిడ అలౌ చేశారు. మినిస్ట్రీ ఆఫ్ హోమ్ అఫైర్స్ పంపించారు NBWని ఎగ్జిక్యూట్ చేయండి. ఆయన అమెరికాలో ఉంటున్నాడు. కానీ అది కూడా మరి త్రూ ప్రాపర్ ఛానల్ అన్న పేరుతోటి దాన్ని వెనక్కి పంపించేశారు. అక్కడ ఫెయిల్యూర్ అయ్యాను నేను.
మీ పేరేంటి
సార్? నేను నరేష్ సార్.
ఓకే, మంచి. ఆయన అడిగే క్వశ్చన్ ఏంటి, నువ్వు చెప్పే సమాధానం లేదు. ఆయన ఇప్పుడు 41A వేరే దేశాల్లో ఉన్న వాళ్ళకి వాట్సాప్ లో పంపిస్తే కుదరదు అంటున్నారు కదా, మరి వాట్ ఈస్ ది అదర్ మోడ్ ఆఫ్ సర్వింగ్ నోటీసెస్ అని అడుగుతున్నారండి.
సారీ సార్. అయితే
మరి అది విని చెప్పండి ఆన్సర్.
సార్ 166 ఆఫ్ లెటర్ ఆఫ్ రిక్వెస్ట్ టు కాంపిటెంట్ అథారిటీ ఫర్ ఇన్వెస్టిగేషన్ ఇన్ ఏ కంట్రీ ఆర్ ప్లేస్ అవుట్ సైడ్ ఇండియా. సార్
ఎన్ని చదివి మాట్లాడమ్మా ఇవి లెటర్ ఆఫ్ రాగట్ ఎన్ని ఛార్జ్ షీట్లు వేసిందాక ఆయన ఇన్వెస్టిగేషన్ లో అడుగుతున్నారు. నువ్వు చెప్పేది లెటర్ ఆఫ్ రాగటరీ అమ్మా. అది నోడల్ ఏజెన్సీ ఉంటుంది. ఇట్స్ నాట్ ఈజీ టు ఇనిషియేట్ ప్రొసీడింగ్స్ 105, 166 అవన్నీ అయ్యే పనులు కాదు కానీ 166 ఇప్పుడు ఆయన అడిగిన దానికి సమాధానం చెప్పి తెలిస్తే.
సారీ సార్, నమస్తే సార్.
నమస్తే. చెప్పరండి, ఎవరో చెప్పండి మా ప్రాసిక్యూటర్లు. ఆల్టర్నేటివ్ మోడ్ ఏందండి మరి? ఇక ఏం లేదా
సార్? ఇన్ కేస్ అతను ఫ్యాక్స్ నెంబర్స్ ఏమైనా అవైలబుల్ ఉంటే త్రూ ఫ్యాక్స్ ద్వారా సర్వ్ చేయొచ్చు సార్. ఇన్ కేస్ ఫ్యాక్స్ కూడా అవైలబిలిటీ లేకపోతే సో అక్యూజ్డ్ వాళ్ళు కోఆపరేటివ్ గా లేరని చెప్పేసి మనం ఛార్జ్ షీట్ 41 నోట్స్ కి అవైలబిలిటీ లేరు, హీఈస్ నాట్ కోఆపరేటింగ్ విత్ ఇన్వెస్టిగేషన్ అని చెప్పేసి ఛార్జ్ షీట్ ఫైల్ చేసి NBW తీసుకుని వారెంట్ ఎగ్జిక్యూట్ చేయొచ్చు సార్.
ఆల్రెడీ బెయిలబుల్ కేసుల్లో ఎలాగా చెయ్యాలని చెప్పేసి సార్ చెప్పారు సార్ 11 గంటలప్పుడు నేను తెలుసుకున్నంత వరకు సార్.
నెక్స్ట్ అండి, ఎవరు మాట్లాడట్లేదు
సార్ ఆల్రెడీ 11
మీరు
గంటలకు
ఆగండి.
చెప్పారు.
నరేష్ గారు మీరు ఆగండి, అందరికి అవకాశం ఇవ్వండి. మీ అందరికి రాయండి. మీరు చెప్పారుగా, కొంతమంది యువకులకు కూడా ఇవ్వు. నువ్వు చాలా అయితే ఎంత 15 ఏళ్ళు సర్వీస్ పుటప్ చేసినట్టున్నారుగా మీరు. ఏమండి?
సారీ సార్, సారీ.
అందరికి చెప్పారుగా మీరు, వేరే వాళ్ళకి కూడా ఇవ్వండి అవకాశం. ఏంటి ఎవరు మాట్లాడట్లేదు? అందరు సైలెంట్ గా. ఇప్పుడు 41A పర్పస్ ఎందుకండి? మీరు ఇందాక అడిగారు 41A పర్పస్ ఏందండి? ఇందాక అడిగిన ఎస్ఐ గారు ఎవరండి?
సార్ రామచంద్రరావు సార్, ఇన్స్పెక్టర్ ఉమెన్ PS కాకినాడ సార్.
బాగున్నా రామచంద్రరావు? బాగా డౌట్లు వస్తున్నాయి.
ఫైన్ సార్, తమరా ఉన్నారు సార్.
అన్నా ఇప్పుడు
మా ఛార్జ్ షీట్లు రిటర్న్ అయిపోయింది సార్ 2 కేసులు. అలాగా మీరు ఎలా
రిటర్న్ చేసింది ఎవరా? జడ్జి మైండ్ ఉండే అసలు అరెస్ట్ అక్కర్లేదని సుప్రీంకోర్టు చెబుతుంటే 41 ఏమని ఏడుందా? సిఆర్పిసి కూడా అమెండ్ చేశారు కదండి, అరెస్ట్ ఆఫ్ అక్యూజ్డ్ ఇస్ నాట్ రికవరీ ఫర్ ఫైలింగ్ ఆఫ్ ఛార్జ్ షీట్ అని.
అవును సార్.
How it is maintainable? 41A serving of notice through WhatsApp.
ఏపీపీ గారు ఎవరు రామచంద్రరావు? మీ ఏపీపీ గారు
రఘువీర్ గారు
నేనే సార్, రఘువీర్ సార్.
మరి ఏంటి, ఏం చేసావా మరి? నువ్వే కదా ఏంటి మరి దానికి రెమెడీ ఏంటి? రఘువీర్ చెప్పు
సార్. ఆ ఛార్జ్ షీట్స్ ఎలా రిటర్న్ అని చెప్పి మా నోటీస్ లో పెట్టలేదు సార్.
వాళ్ళు ఇప్పుడు చెప్పాడు, ఇప్పుడు ఏంటి రెమెడీ ఏంటి చెప్పు
సార్. తమరు ఇప్పుడు ఆల్రెడీ చెప్పిందే సార్, ఎందుకంటే మా అరెస్ట్ అనేది మ్యాండేటరీ కాదు సార్ ఛార్జ్ షీట్ వేయడానికి. సో 41A నోటీస్కి అవైలబిలిటీ వాళ్ళ లేకపోతే ఇన్ కేస్ అబ్స్కాండింగ్ ఛార్జ్ షీట్ కానీ వాళ్ళ అవైలబిలిటీ లేదని చెప్పి అదే విషయం ఛార్జ్ షీట్ లో మెన్షన్ చేస్తూ ఛార్జ్ షీట్స్ వేయచ్చు సార్.
ఎక్కడుంది అని ఎక్కడుందంట?
సార్ అర్థం కాలేదు సార్.
అంటే అరెస్ట్ చేయకుండా ఛార్జ్ షీట్ వేయించానే సరే, కొత్త సిఆర్పిసిలో పెట్టారు. కొత్త పిఎన్ఎస్ పాత దానికి మరి పాత ఆవిడికి
సార్ పాత ప్రాక్టీస్ లో కూడా ఇన్ కేస్ అక్యూజ్డ్ అవైలబిలిటీ లేకపోతే ది యూజ్ టు ఫైల్ ద ఛార్జ్ షీట్ సార్ యాజ్ అబ్స్కాండింగ్.
నిజమేనండి, జడ్జి టేకింగ్ అబ్జెక్షన్, అరెస్ట్ చేయింది నేను నెంబర్ అంటున్నాడు. హౌ విల్ కమ్ అక్రాస్?
రీసెంట్ గా దాని మీద ఒక వెర్డిక్ట్ కూడా వచ్చింది సార్.
ఏంటి చెప్పు
సార్. ఇప్పుడు
ఇండియన్ ఎంబసీ ద్వారా డిప్లొమాటిక్ ఛానల్స్ ఇండియన్ ఎంబసీ ద్వారా సర్వ్ చేయాలంటున్నారు సార్. ఇది
అక్కడ దాకా
అది
ఉంది.
పక్కన
సత్యేంద్ర
పెట్టవా,
పాటిల్
అడిగే క్వశ్చన్ ఏంటి,
సార్
మీరు
కేసులో
ఆన్సర్
ఉంది సార్.
చెప్పేది ఏంటా రాజశేఖర్?
సత్యేంద్ర కుమార్ అంటిల్
అంటే
కేసులో
వాట్సాప్
సార్
అయ్యి కన్సిడర్ చేయకపోతే, వాట్సాప్ ఈమెయిల్ ద్వారా కన్సిడర్ చేయకపోతే డిప్లొమాటిక్ ఛానల్ ఇండియన్ ఎంబసీ ద్వారా సర్వ్ చేసుకోండి అంటున్నారు.
చెప్పండి, ఆయన చెప్తున్నాడు, కిషోర్ అని చెప్తున్నాడు, చెప్పండి కిషోర్.
సార్ సత్యేంద్ర కుమార్ అంటిల్ కేసులో సార్ 7 years లోపు నాటి ఛార్జ్ షీట్ డైరెక్ట్ వేసేయమన్నారు సార్. ఏ అండ్ బి అండ్ సి అనే లెజిస్లేషన్ బెయిల్ అఫెన్సెస్ ఏబిసిడి కేటగిరీ కింద డివైడ్ చేశారు సార్. ఏ కేటగిరీకి వచ్చి అప్ టు 7 years ఉన్నదాన్ని ఏ కేటగిరీ కింద ఉంటారు సార్. ఛార్జ్ షీట్ డైరెక్ట్ లో ఫైల్ చేయమన్నారు సార్. అందులో సమన్స్
నీ ముందు ఇంకొక ఆయన చెబుతున్నాడు చూడు, రెలవెంట్ జడ్జిమెంట్. నీ ముందు ఎవరు చెబుతున్నారు? ఇందా ఎవరు మాట్లాడుతున్నారు? ఎవరంటే జడ్జిమెంట్ ఏది చెబుతున్నారు?
సార్ సిద్ధార్థ్ వర్సెస్ స్టేట్ ఆఫ్ యూపీలో సుప్రీం కోర్ట్ వారు 2021 లో చెప్పారు సార్, దెర్ ఇస్ నో ఆబ్లిగేషన్ ఆన్ ది పార్ట్ ఆఫ్ ది ఇన్వెస్టిగేటింగ్ ఆఫీసర్ టు ఫైల్ ఎ చార్జ్.
2012లో అనిల్ కుమార్ సింగ్ వర్సెస్ స్టేట్ ఆఫ్ ఏపీ. అంతేనా? 2012, 2007 నుంచి అరెస్ట్ ఈజ్ నాట్ ఏ ప్రీ కండిషన్ ఫర్ ఫైలింగ్ ఆఫ్ ఛార్జ్ షీట్. అనిల్ కుమార్ సింగ్ వర్సెస్ స్టేట్ ఆఫ్ యూపీ. తర్వాత అది మీ సత్యేంద్ర కుమార్ దానికి వారెంట్లు ఇవ్వద్దు అనేది, అది గైడ్ లైన్స్. సిద్ధార్థ కేసెస్ కాంటెక్స్ట్, సిద్ధార్థ కేసెస్ కరెక్ట్ కేస్ ఫర్ దట్. రామచంద్ర, నీ ప్రాబ్లం అయిపోయిందా? రామచంద్ర
సార్ అర్థమైంది సార్. సార్ అర్థమైంది సార్. అయితే సార్ ఈ మధ్యకాలంలో సుప్రీంకోర్టు ఒక 1 month క్రితం ఈ 41 సిఆర్పిసి నోటీసు త్రూ ఎలక్ట్రానిక్ మోడ్ లో సర్వ్ చేయడానికి లేదని చెప్పేసి
వాస్తవం మాట్లాడుతున్నారు. అయితే నిజంగానే పోలీసులు నోటీసు లేకుండా రెఫ్యూజ్డ్ అని రాస్తారు. ఇక వాట్సాప్ లో పంపించి ఆడ అరెస్టులు చేస్తారని సుప్రీంకోర్టు వాళ్ళు భయపడి, అరే బాబు నిజంగా ఇవ్వండి రా బాబు అని చెప్పారు. వాళ్ళ బాధ వాళ్ళది. మనం నిజంగా సర్వ్ చేయం కదా, ప్రాక్టికల్ గా మాట్లాడుతున్నాం. అందుకని మిస్యూజ్ అయిద్దని అలా చేయొద్దని చెప్పారు. దానికి మోడ్ ఏంటంటే రిజిస్టర్ పోస్టో లేకపోతే పోస్ట్ లో పంపించచ్చు. మనకి అదర్ మోడ్ ఇస్ దేర్, పోస్ట్ లో పంపించు. అది ఎలక్ట్రానిక్ ఎవిడెన్స్ నమ్మట్లేదు వాళ్ళు. 41A అనేది ఇప్పుడు 41A రిఫ్యూజ్ చేశాడని రాస్తావు, నువ్వు రాలేదని రాస్తావు. వాట్సాప్ నా నెంబర్ ఒకటి ఉంటుంది, నేను చూడకపోవచ్చు కదా టైం సెన్స్ లో. అంత మాత్రం నువ్వేం చేసేస్తావు, చూశాడండి రాలేదని మరుసటి రోజు పోయి అరెస్ట్ చేసుకొస్తావు. మిస్యూజ్ అవట్లా. దట్ ఈస్ ది ఇంటెన్షన్ ఆఫ్ ది సుప్రీం కోర్ట్. అందుకని మనం ఏం చేయాలా, రిజిస్టర్ పోస్టులు పంపించాలా. వేరే దేశంలో ఉన్నా కూడా పోస్ట్ ఉంది కదా, పోస్ట్ లో పంపించు, విత్ అక్నాలజ్మెంట్ వేయి. ఛార్జ్ షీట్ కి అసలు ఏ కేసులో అరెస్ట్ అనేది ముఖ్యమే కాదండి. 41A ఏంటంటే ఓన్లీ ఫర్ ది పర్పస్ ఆఫ్ ఇన్వెస్టిగేషన్ ఆఫీసర్ డైరెక్టింగ్ ది అక్యూజ్డ్ ఫర్ ది పర్పస్ ఆఫ్ కోఆపరేటింగ్ విత్ ఇన్వెస్టిగేషన్. అసలు అది కోర్టుకి ఏ సంబంధం? 41A ఇచ్చావా లేదా అని బెయిల్ బాండ్స్ చేయమంటాం, అవన్నీ తప్పు కదా. ఇప్పుడు వాళ్ళు చెప్పే కేసు సత్యేంద్ర కుమార్ కేసు అవన్నీ అయ్యే కదా. అంటే సిద్ధార్థ కేసు, అనిల్ కుమార్ సింగ్ కేసులో అయితే ప్రతి కోర్టులో హైకోర్టు వాళ్ళు పెట్టమన్నారు పోలీసుల్ని. ఏంటి ప్రింటర్లు ఇవన్నీ ఫోటోస్టాట్ మిషన్లు పెట్టమంటే సుప్రీంకోర్టుకి వచ్చి తిట్టకుండా తిట్టారు వాళ్ళని. అట్లా ఇవన్నీ వేస్ట్ అన్నమాట.
చార్జ్ షీట్ నెంబర్ అవ్వలేదు సార్. ఇప్పుడు మేము మా పీపీ గారు
చెప్పాగా, పీపీ గారు చేసి పెడతారు.
నమస్తే సార్.
నమస్తే. ఆయన క్లాస్ చెప్పేసుకుంటున్నారు తెలియక, ఇప్పుడు మాట్లాడితే వస్తున్నారు. ఇప్పుడు మనం కట్ అయిపోయినా ఆయనకి ఐడియా లేదు. ఏసీఏ గారు చెప్పు, ఏం పని ఉందా? ఏలూరు మహిళ.
సుబ్బారావు సార్ కూడా ఏదో చెప్పేస్తున్నారు సార్, మనకేం అర్థం వినపట్లేదు సార్.
అదే సీఏ గారిని అడుగుతున్నా. ఏంటి సీఏ గారు ఏమన్నా?
సార్ నమస్తే సార్.
నమస్తే.
మై నాలెడ్జ్ కన్సర్న్డ్ అందాక డిస్కస్ చేశారు. నోటీస్ నాట్ మ్యాండేటరీ టు ఇష్యూ నోటీస్ టు ది కన్సర్న్ అని చెప్పి, ఇన్ బిలో 7 years అని చెప్పి చాలా మంది చెప్పారు. అలాగే దానికి సుప్రీంకోర్టు జడ్జిమెంట్స్ ఉన్నాయని కూడా చెప్పారు. కానీ యాక్చువల్ గా 35 clause 3 BNSS లో ఒక వర్డ్ చెప్పాడు సార్. ది పోలీస్ ఆఫీసర్ షెల్ ఇన్ ఆల్ కేసెస్ వేర్ ద అరెస్ట్ ఆఫ్ ఎ పర్సన్ ఈజ్ నాట్ రిక్వైర్డ్ under subsection 1 issue a notice directing the person against whom a reasonable complaint has been made or credible information has been received or a reasonable suspicion exists that he has committed a cognizable offense to appear before him to such other అని చెప్పి ఇక్కడ ఇచ్చాడు. దీని ముఖ్య ఉద్దేశం ఏంటంటే సార్, నాకు మై ఒపీనియన్, నేను దాన్ని కట్టలేదు. మనకి ఇండియన్ కాన్స్టిట్యూషన్ లో కూడా ఒక రైట్ ఉంది, ముద్దాయి అవ్వచ్చు, ముద్దాయి కూడా ఏదైనా అఫెన్స్ వాడి మీద మనం అట్రిబ్యూట్ చేసేటప్పుడు వాడు కూడా దాన్ని డిఫెన్స్ చేసుకునే అధికారం ఇచ్చాడు. దాన్ని కన్సల్ట్ చేసుకుని ఇప్పుడు నేరం ఒకటి చేశాడు అని మనం వాడి మీద మనం చేసేటప్పుడు నోటీస్ అడిగి ఇస్తే వాడు ఏమైనా నేరం నేను చేయలేదు, నాకు ఎవిడెన్స్ ఉంది అని చెప్పుకోవడానికి అవకాశం ఉంటుందనే ఉద్దేశంతో ఈ నోటీస్ అనేది ఇవ్వాలనేది మన చట్టంలో పెట్టారు. అలాగే కొన్ని కోర్టుల్లో కూడా సుప్రీంకోర్టు చెప్పింది అనేది నా ఉద్దేశం.
సార్ వచ్చారు తర్వాత మాట్లాడదాం.
I hope it got disconnected in between. Please let me know what is the last side you are able to see. I will start from that. Did you follow the cost issue?
No, not yet completed by that time.
Okay. And confidentiality.
We are at confidentiality. Yeah.
Okay. So the information shared or the information obtained under this MLATs is highly confidential. It cannot be shared. The requested share shall, upon a request, keep confidential the request for assistance. If at all you want to share this information, or where you feel that the confidentiality cannot be maintained, then you should inform the other state about this aspect, and then the other state will take a call whether to share information or not to share information. So that is very, very important aspect. And I share one practical case here to speak about the confidentiality. This is with reference to a case before the Supreme Court filed by Sri Ramjit Malani about disclosure of some information shared under some treaties between the government of India and the Swiss government and Liechtenstein. This information pertains to the details of a persons and details of their bank accounts in a foreign jurisdiction. No doubt it pertains to some particular case of unaccounted money or black money or tax evasion and corruption issues. But the point here is that there is a clause in the treaty that India signed with Switzerland and Liechtenstein that the information shared is confidential. So the question is whether the information can be shared or not. We examined that aspect, and I advised that the information cannot be shared. Of course, the information can be shared once a case is filed under the Income Tax Act and the matter is pending before the court or the ITAT, and once the information is shared, then it can be a public document. Till that time, it is confidential, it cannot be shared. That's what we explained and appraised. However, we said that we advised the Finance Ministry, you may appraise the Supreme Court by giving the details in a sealed cover rather than opening the details before the open court. And that has been considered by the Supreme Court. And this is what I want to say, that confidentiality is very, very important, because sometimes these issues may even pertain to the national security or national interest or the safety of the persons concerned. So therefore, confidentiality is very, very important. The next important aspect to be considered with reference to the mutual legal assistance is the cost. Who will bear the cost? Because getting information, transfer of a person from one jurisdiction to another jurisdiction, transfer of the proceeds of the crime or the documents, as the case may be, involves the cost. So the cost of the executing the request for the legal assistance shall be borne by the requested state. If India is a requested state, then India should bear the cost. Requesting state shall bear the expenses for the transfer of the persons in custody to its territory. In case of transfer of persons, then the cost will be borne by the requesting state and the expenses and the fee of the experts in the requested state. If it is difficult to bear the expenses, because sometimes it may involve extraordinary expenses. It may involve extraordinary expenses. So such cases, the contracting states will consult each other and determine the terms and conditions under which the requested assistance can be provided. This is how the cost shall be shared by the parties. Friends, ladies and gentlemen, so far we discussed about the various provisions of the MLAT, the scope of the MLAT, and also the substantive advantages of having an MLAT for conducting a criminal case. Now, after MLAT, I also mentioned that MLAT has no jurisdiction in case of a bailable arrest warrant. So, bailable arrest warrant will be handled under the Extradition treaty. Extradition treaty is pursuant to the provisions of the Extradition Act. Extradition Act is enacted to consolidate and amend the law relating to the extradition of the fugitive criminals and to provide matters connected therewith. An extradition offense means in relation to a foreign state being a treaty state, an offense provided for in the extradition treaty. Do you remember what shall be an extradition offense? You must mention in your extradition treaty. Friends, ladies and gentlemen, usually extradition treaty is extradition offense. Yes, madam. Any question? Extradition offense is linked with the principle of dual criminality. That means the offense for which you are asking extradition shall be an offense in both the jurisdictions. Suppose if it is an extradition request from Singapore, the offense what you allege shall be an offense in both India and Singapore, and it must be punishable with imprisonment for a term which shall not be less than 1 year. So 1 year imprisonment shall be there. It shall be an offense in both the jurisdictions. Then only extradition is possible under the extradition treaty. And let us see what extradition denotes. Extradition, the term extradition denotes, this is as observed by the Honorable Supreme Court in Rosalyn George versus Union of India, where the Supreme Court held that the term extradition denotes the process whereby under a concluded treaty, one state surrenders to another state at its request a person. It is nothing but surrendering of a person from one state to another state. And extradition is founded on the broad principle that it is the interest of the civilized communities that criminals should not go unpunished. So the purpose and object of this extradition is criminals shall not go unpunished. By taking shelter in other jurisdictions, they should not go unpunished. Because if they go unpunished, it shakes the confidence of the people in criminal justice administration. So therefore, extradition plays a very important role in conducting of criminal cases and in criminal justice administration, enabling the investigating agencies or the prosecutors to avail the route of extradition for handling of the cases before the various courts. Here, we have two kinds of arrangements with regard to extradition. One is, with some countries, we simply had an extradition arrangement, but not an extradition treaty as such. With 12 countries, we are having this kind of an arrangement. They are Antigua, Barbuda, Fiji, Italy, Papua Guinea, Singapore, Sri Lanka, Sweden, Tanzania, Thailand, Croatia, New Zealand, and Armenia. These are the countries with whom we had extradition arrangements. Arrangement is different from extradition treaty. And extradition treaties are with more than 30 countries. These are the countries, I'm just flagging them for your kind perusal and understanding, and make reference of the same in due course of time as and when required. So these are the countries with whom we had the extradition treaties. As I mentioned and explained you, treaty is nothing but an enforceable agreement. Apart from extradition treaties, mutual legal assistance treaties, this mutual legal assistance is also permissible under certain international conventions that India signed. What are they? They are also related to the mutual legal assistance, but they are not mutual legal assistance treaties as such. They are United Nations conventions. They are multilateral treaties. They are United Nations Convention against the transnational organized crime, which we call UNCTAD. This is a transnational convention to control, to regulate, to monitor transnational organized crimes. And the second important convention is United Nations Convention against the corruption. I hope some of you frequently use this convention. India is signatory to this convention. India ratified this convention. But I must say one important aspect regarding United Nations Convention Against Corruption. That is, while signing this United Nations Convention Against Corruption, India took a reservation. When you are signing a treaty or ratifying a treaty, you are empowered or entitled to make some reservations. For example, while signing the WTO agreements, India had a reservation for subsidies, right? This grants and for agricultural issues. So that's a reservation India had. Therefore, there is a pressure on India to remove these reservations, but still India is retaining these reservations. Like that, while signing this convention, India took a reservation that for mutual assistance, India will not invoke the United Nations Convention Against the Corruption route, but India will invoke the bilateral route. So that is a reservation we had. So therefore, under UNCOC, bilateral cooperation may not be that easy or that possible. United Nations, then another important convention is United Nations Convention Against Illicit Traffic in Narcotic Drugs and Psychotropic Substances, which is popularly known as Vienna Convention. So cooperation is also possible, permissible under this convention. And the Hague Convention. Hague Convention is basically for processing of documents and summons, which I explained in earlier slides. And I must say here, for Hague Convention, the Ministry of Law and Justice, Department of Legal Affairs, that is we are the central authority for processing of documents and summons or even judgments. And we have a central authority. The competent authority is one Mr. J.B. Dubey, my colleague. He is in charge of this central authority, and he is a man who processes all the summons and documents under the Hague Convention. The SARC Convention is another important convention where mutual assistance is permissible. Commonwealth Scheme is another arrangement for mutual legal assistance as far as cooperation is concerned. Apart from this mutual legal assistance and various conventions and international arrangements, there is another mechanism for assistance or mutual cooperation, that is a letter of rogatory. I hope some of you might have used this route or this mechanism. It is nothing, letter of rogatory is nothing but a formal communication in writing sent by one court to another court, pending located in a foreign jurisdiction, or a judge requesting that the testimony of a witness residing within the jurisdiction of that foreign court may be formally taken thereon under its direction and transmitted to the issuing court, making such request for use in a pending case. This request is entirely depends upon the committee of the courts. Committee is nothing but an understanding between the courts, that is between India and UK. If there is a good understanding, the Indian judge can send a letter of rogatory to the foreign court. The foreign court may reciprocate on that. It all depends upon the relation the court maintain with the foreign courts. If the relations are not good, there may not be response to the letter of rogatory. And letter of rogatory may be used to affect service of process. Basically, service of process, it is irrespective of any convention or any treaty. Even if there is no convention, letter of rogatory can be processed. Earlier, letter of rogatory is to be transmitted via consular or diplomatic channels, thereby the time-taking process is to be too long. Now, subsequent to ratification of the Hague Service Convention 1965, this process is changed. Now, the letter of rogatory can be issued through Hague Convention. As I mentioned, we are the central authority for the Hague Convention. And this letter of rogatory is irrespective of any multilateral or bilateral treaty. Now, I draw your attention to a very important case where the mutual legal assistance is denied by India on the ground that there is no MLAT between India and Pakistan. It's a case that was decided by the International Court of Justice, popularly known as Kulbhushan Yadav's case, India-Pakistan. I hope all of you are aware or might have read about this case through media. Mr. Kulbhushan Yadav is detained by Pakistan and he was subjected to criminal proceedings and he was sentenced with death sentence on the ground that Yadav is involved in espionage and terrorism activities in Pakistan. Friends, ladies and gentlemen, I draw your attention to one of the important conventions to explain this particular case. That is Vienna Convention on Consular Access. The Vienna Convention on Consular Access enables the states to meet the accused if any detained by a foreign agency or foreign territory. Suppose if an Indian is detained in UK, by exercising the provisions of Vienna Convention on Consular Access, the government of India can have audience with the that particular person. But that was denied and declined in this case by Pakistan. on the ground that India failed to cooperate Pakistan and India failed to provide assistance in providing information with reference to Jadav's espionage and terrorism activities, and by describing it as a false cover name and authentic passport. They sought some information on this point, which India declined. India argued that there is no mutual legal assistance treaty between India and Pakistan to share the information. So therefore, India has no obligation to share. And apart from that, the mutual legal assistance is not linked with the Vienna Convention on the law of the consular access. So therefore, Pakistan's claim is not tenable. This was accepted by the International Court of Justice. That's how we got access to consular access to Mr. Kulbhushan Yadav. Ultimately, we also fought that case. Friends, ladies and gentlemen, apart from all these agreements and arrangements, there is also a scope for this kind of an arrangement and assistance under the Prevention of Money Laundering Act. You know, Prevention of Money Laundering Act is also one of the important piece of legislation enacted to control and prevent terrorist activities or funding for terrorist activities by describing it as a proceeds of the crime. And proceeds of crime and money laundering is linked with the predicate offense under Schedule of the Prevention of Money Laundering Act. Section 3 defines what is money laundering. And in case of money laundering cases, there can be an agreement, and that agreement can be entered by the central government by invoking the power under Section 56. Once the agreement is entered, the central government will notify in the official gazette that the country with whom we had an agreement is a reciprocating territory for India. Once it is notified as a reciprocating territory, the exchange of information, the cooperation, coordination, all these are possible. So this is another arrangement under the Prevention of Money Laundering Act. I draw your attention to another important case, the Canadian Supreme Court in Canada versus Skimdate. This is a case, and here it pertains to extradition law, where the court held that for extradition, there has to be an amalgamation of international law and national law. Remember, all these agreements, the cooperation is linked with the two important aspects. One aspect is the agreement what you had with them, and the domestic law, the provision what you are having. Normally, in extradition law, the requested state is to follow the rule of non-inquiry, which means that the requested state is not to normally make inquiry about the nature of criminal justice system. When a request is made for extradition, you are not supposed to examine what is a criminal justice system that is prevailing in that state. You have to see whether the person can be extradited or not, whether the person is fulfilling the dual criminality or not. But in this case, this is what the court held, that the actual conduct of the trial of the extradited accused is left to the criminal jurisprudence followed in the requesting state. So it is the requesting state which will follow the procedure. So the rule of non-inquiry is a well-developed norm both in Canada and America. It is a case between Canada and America. So if a request is made from America, America cannot examine and cannot inquire whether the criminal justice system that is prevalent in Canada is right or wrong. Similarly, if a request is made to Singapore, Singapore cannot examine the request made by India, the criminal justice system in India is proper or not, is just or not. So that is what the principle evolved here in this particular case. This is another important case. In this case, it's a case between CBI and Abhishek Verma. It is a case pertaining to mutual legal assistance with reference to examination of a person through video conferencing. So in this case, by placing reliance on the video conferencing rules by the High Court of Delhi, notified dated 1/6/2020, it was specifically stated by the Delhi High Court that notwithstanding the provisions of clause 5.3.1, that is the rules, where the witness's examination is to take place in a criminal case of a person located outside the country, the provisions of the comprehensive guidelines for investigation abroad and issue of letter of regulatory, mutual legal assistance requests, and service of summons, notices, judicial documents in respect of the criminal matters, mutual legal assistance will be followed to the extent they comport with the provisions of the CRPC and evidence. Remember, whenever there is any request for video conferencing or examination, you must ensure that the request is as per the provisions of the guidelines for video conferencing as per the provisions of the letter of regulatory or the mutual legal assistance or the domestic law of your nation. If the domestic law of your nation is contradicting, say for example, you made a request from Australia. If the Australia feels that the request what you made, the video conferencing what you are requesting is against their domestic law and is not accordance with the provisions of mutual legal assistance, then the Australian authorities can decline your request. That's what the Supreme Court, the Honorable Delhi High Court reiterated in this particular case. This is another case. This is another case. It's a state by Superintendent of Police, National Investigating Agency, Kochi versus Shakul Ahmad. Here, the respondents were involved in criminal conspiracy and they formed and facilitated their travel. See, this is what I mentioned. The network of the criminals is very active and huge. They facilitate escape from one jurisdiction to another jurisdiction. In this case, the respondents were involved in criminal conspiracy and they formed and facilitated their travel from India to Syria to join IS. And NI, National Investigating Agency, registered a case. In this case, requests have been sent to the Republic of Singapore under the MLAT between Republic of India and Republic of Singapore. So this is how you procure information under the Mutual Legal Assistance Treaty. And another important case is Abu Anas and others versus National Investigating Agency. Here NIA sent Mutual Legal Assistance Treaty to USA and UAE and Canada. Friends, ladies and gentlemen, if the assistance is required from only one country, the things may be easier. If the assistance is required from more than one country, then things will be tougher and difficult. Here in this case, the information is sought from three major jurisdictions: United States of America, United Arab Emirates, and Canada, requesting to provide evidence regarding social media and other digital communication. Our learned friend, Director of Prosecution, has mentioned about digital communication and use of digital technology in commission of the crimes. That's exactly involved in this case. The digital instruments are used for communication, but the communication server is located somewhere else, the origin of the communication. So to unearth this origin of communication and larger conspiracy, who communicated to whom, from where to where, you need some assistance or information. And this is a larger conspiracy by the IS activities. So India sought information from USA, UAE, and Canada, and by invoking the provisions of mutual legal assistance. I just draw your attention to the Antrix Devas case to explain about its consequences and its importance under the MLAT. Antrix Devas case is basically pertaining to an agreement for usage of satellite connectivity, S-band. S-band is a satellite connectivity. So there is an agreement between Antrix and a corporate wing of ISRO, International Satellite Research Organization, ISRO, a wing of the government of India under the Department of Space. It is an autonomous, independent research body in the space technology. So it has a corporate wing, that is Antrix. Antrix entered into an agreement with Devas Multimedia, a German company where Singaporean equity shareholders are also there, Mauritius shareholders are also there. So here, while entering into this agreement, there is a fraud and corruption by Devas. Devas is originally having expertise for internet connectivity, but not satellite connectivity. But the agreement what they signed with the Antrix is about satellite connectivity. They produced some false documents that they have the satellite connectivity capabilities. At the time, they are not at all capable of having the satellite connectivity. Their capability is only about internet connectivity. So the agreement was signed. After signing of the agreement, it was realized that S-band is an important satellite connectivity, and it is mainly relating to the security aspects of the nation. National security is involved. So after realizing, the Antrix cancelled the contract with Antrix Devas. This is the background of the case. Now, to investigate this case of obtaining an agreement by fraud and corruption is a criminal aspect. The investigating agencies like CBI, NIA, and ED are investigated the case. There's still investigation going on. Charge sheet was filed in 2016. But the persons involved in Devas Multimedia at the relevant point of time when this contract was signed, when the fraud and corruption took place, are residing in different jurisdictions like USA, Singapore, Mauritius, and Malaysia, and other countries. So you have to have communication from them, transfer of persons for hearing. Unless a person is transferred and deposed before the court, your criminal case will not proceed further. Unless you get the appropriate documents from these jurisdictions, your criminal case will not go further. While examining this case, you can go through this judgment also, a very important judgment. The Honorable Supreme Court held that the incorporation of Devas Multimedia in India is by fraud and corrupt means. It is a fraudulent company. So therefore, the company is non-est in the eye of law. When a company is incorporated from fraud and corruption and fraudulent angle, the company has to liquidate. The company has to be closed. That's what the law is saying. So the company is non-est because its incorporation is by fraud and corruption. That's what the Supreme Court held. Supreme Court held that it is not just fraud against India, it is fraud against the government of India, it's a fraud against the public. The Supreme Court identified 7 kinds of frauds, 8 kinds of frauds, I'm sorry. And this was held as a public fraud. So this is the case. Here we are having a position where you have to correspond with the United States, you have to correspond with Singapore, you have to correspond with Mauritius, you have to correspond with Malaysia, Maldives, getting information. So what is our way out? Way out is only your MLAT. Except MLAT, you don't have any other option. So these are the cases pertaining to MLAT or highlight the significance of MLAT. Now come to the other aspect of the MLAT, the challenges of the MLAT. No doubt, MLAT facilitates you with some information, transfer of persons, recording, all this. But MLAT also poses challenges. One important challenge is identity of a person and correct address. You may give some address, but the person may change his address there after going to a foreign territory. Identity of a person is very, very important. As I mentioned in earlier, while explaining earlier slides, identity. He may change his passport. Very recently, we got a reference from United States asking us to share the biometric information of certain people to identify them. Even we asked permission from the Ministry of External Affairs to share the biometric information what they get at the time of passport. The question here is, can the Ministry of External Affairs share the biometric information with National Investigating Agency for conducting a particular case? Because here, NIA is having a problem in the identity of a person. NIA has given the details of X, son of Y, residing at Z address. But on investigation by the authorities in US, they found that he is not X, he is XY, son of YZ, residing at W place. So US authorities expressed a concern that there is a change in the address, there is a change in the identity. So how to nab him? NIA says, reaffirms that no, he is the same person, he is changing his identity. Then they asked us, you please give us a biometric information so that we will share the biometric information with the US agencies to catch them. So this is the challenge of an identity of a person, correct address. So you must ensure while forwarding a request to meet this challenge. Communication gaps in the assistance, gaps in the assistance is an important aspect. You have to identify the communication gaps, And the most important challenge is long response time. Sometimes the requested state may take long time for identifying the issue or for extending the cooperation. Taking such a long time may have an impediment before the court, may have impediment on the case which you are handling. That's why long response time is another challenge under the MLAT. Location in multiple jurisdictions and assistance from different authorities, another big challenge. I shared one example of Antrix Devas, and also case where request is sent by national investigating agencies to USA, UAE, and other countries. Delay before the courts. Sometimes the courts may not act promptly, and thereby they delay. Problem of examination of witnesses, access to the documents. And there is another challenge. Differences in legal and judicial systems, because India has a different judicial system, legal system. The legal and judicial system in other countries may be different. Sometimes even your MLAT request can be challenged before the court. Suppose if a person against whom you sent a request can challenge that before the local courts where he is residing. Similarly, if London, UK is asking you for some information or some exchange, and the person who is located in India, he may challenge that before the. So that is another big issue, delay in getting assistance. These are the challenges under the MLAT. Now we'll see one case about the limits to MLAT evidence before the Canadian courts. It's an example from Canadian court to explain about the problems of MLAT. In this case, Canada, the use of MLATs was recently considered in a case called Rajaratnam. In Rajaratnam, 4 accused were charged. In this case, 4 accused were charged for organizing, inducing, aiding, and abetting people to come to Canada, colloquially known as human smuggling. This is a case relating to the human smuggling. And on this count, the persons were arrested for in contravention of Section 117 of the Canada's Immigration and Refugee Protection Act. This is the 4 persons. And here the issue involved is that the persons arrested are also linked with this human smuggling, and the case relates to some police officers in Thailand. The Canadian authorities have to examine these police authorities in Thailand to substantiate this case. So mutual legal assistance was sought under the Mutual Assistance in Criminal Matters Act. Friends, ladies and gentlemen, I also mention here one important aspect, that some of the jurisdictions have a separate enactments for mutual legal assistance in criminal cases. Though we have a provision under the CRPC, we don't have any standalone legislation to extend assistance in case of criminal matters through a legislation as it was prevalent in case of Canada. When this assistance was sought, the 3 of the 4 accused filed a case, challenged the validity of this particular section before the court. And the court held that it is a violation of their human rights. So thereby, the mutual legal assistance could not be exercised because they challenged this very purpose. So legal challenges is another important aspect to realize the threats or the delays under the mutual legal assistance. This is another important case. International investigations require international cooperation. To extend this cooperation, you have to have a strong relation between the 2 countries. This is a case by the United Kingdom Supreme Court. It's a case in KBR highlighted an attempt by the government agency. It's relating to serious fraud organization. The serious fraud organization initiated some proceedings in connection with the bribery and corruption involving KBR Limited, a UK-based corporation that itself is a subsidiary of KBR. The KBR is an American engineering and technical consulting company, and this KBR in UK is a subsidiary of that. In April 2017, the SFO issued a section notice to KBR Limited requiring it to produce specified documents and information. They sought some information and documents. Traditionally, SFO interprets the provision taking the position that it provides investigators. This is an information sought by SFO relating to the fraud and corruption played by a company. And they try to invoke certain provisions of the Act, that is Criminal Justice Act 1987. The question here is, and it is also related to the exchange of information between 2 nations, the UK and US. So the question here is, can the SFO invoke the provisions of this criminal justice or not? That is a issue challenged before the court. The High Court dismissed, saying that it's not possible for SFO to invoke that, and the Supreme Court confirmed that is not intended to have extraterritorial jurisdiction because the information sought by SFO under the MLAT is on the basis of this Criminal Justice Act 1987. So the question here is whether this Criminal Justice Act had extraterritorial jurisdiction to enable SFO to get the information from the United States or not. The UK courts held that they have they don't have the jurisdiction, and the same was confirmed. So by virtue of this, we can draw an inference that the intervention by the local courts or challenge before the local courts may lead to some problem in getting information or assistance or cooperation under the MLAT. So therefore, friends, ladies and gentlemen, there is a little doubt that MLATs have potential to facilitate and ease the provision of legal assistance in cooperation. No doubt they definitely facilitate. However, there may be some lapses, there may be some issues or some challenges, like we discussed in case of UK and USA or in Canada, where the local courts intervene and became a hurdle in enforcing the assistance or cooperation under the MLAT. However, there is no hard and fast rule that this should be the case, this should be the rule in all cases. It all depends upon the facts and circumstances of the case. So the assistance requires a case-by-case examination depending on the series of legal, political, and practical factors. So a standard format of a legal MLAT request would prima facie make the process easier to initiate and comply with for the law enforcing agencies. One important aspect would be adequate training of the law enforcement officials to understand the use of the MLAT system more effectively. But at the same time, law being a living organ has to grow in order to satisfy the needs of the fast-changing society and keep abreast with the economic developments taking place in the country. As new situations arises, then the law has to be evolved in order to meet the new challenges such as the situations. Law cannot afford to remain static. We have to evolve new principles and lay down the new norms which would adequately deal with the new problems which arise in a highly industrial economy. With these words, with the advent of the artificial intelligence, with the advent of the digitalization, with the advent of the e-courts, I'm sure we may come across with some new provisions of law to tackle the problems or the issues, if any, under the MLAT. But certainly MLAT plays an important role in the conducting of a criminal case and in administration of criminal justice system. With these words, I stop here and thank you all for your patient hearing, and thanks to the Director of Prosecution, Sri Koteswarao Garu, on behalf of the government of Andhra Pradesh, for affording me this wonderful opportunity. And I'm sure, and I'm very right in saying that this kind of programs will definitely stimulate new ideas, new thoughts to meet the challenges and look ahead for this kind of interactions in due course of time, considering it as a great pleasure and privilege. And I'll be happy to answer if there are any questions in this regard. Thank you. Back to Koteswarao Garu.
Thank you, Jogara Garu. Okay, P. Susila Garu. Susila. Susila Garu, please raise your hands. If anybody want to ask question, please raise your hands and we'll tell them. First, P. Susila. Ma adugnara Susila Garu. నెక్స్ట్ అడగండి, పోనీ నెక్స్ట్ ఎవరన్నా అడిగే వాళ్ళు అడగండి. వినపడుతుందండి?
Sir, can I ask a question, sir?
Okay, yeah.
Yes, sir.
Some brief inputs about lookout circular, red corner notice, and other notices involved, sir. Some brief idea.
That depends upon the facts and circumstances of the case. Say where you want to issue a lookout notice and red corner notice, you have to justify that and you have to extend this, because it is also linked with various international conventions, is also involvement of Interpol. So therefore, you have to justify for issuing of this lookout notice or red corner by substantiating the reason for lookout notice and red corner, and it also meet the international standards. Then only it can be considered. Otherwise, there is a possibility of declining our request. It all depends upon the facts and circumstances. We cannot say that this shall be the yardstick for issuing of this lookout and red corner notice.
Yes, sir. Thank you, sir. If there is a dispute between about the mutual legal agreement between the two treaty countries. What is the forum to resolve the issue?
Under the MLAT, there will be a provision saying that in case if there is an issue regarding interpretation or understanding or application of the provisions of the treaty, then the matter shall be resolved through mutual discussions and negotiations through diplomatic channels. That is a way of resolving the disputes. Suppose, so far there is no such incident happened in case of India, but suppose if there is a case where the issue is not resolved by means of these mutual negotiations or diplomatic channels, then you have a right to agitate it before the International Court of Justice regarding the breach of the treaty provisions or the breach of the commitments, as we invoked the jurisdiction of the ICJ in case of Kulbhushan Yadav's case. But it all depends upon the facts and circumstances. Generally, usually, it will be resolved through mutual negotiations and through diplomatic channels.
So the ICJ judgment order is binding on the final order is binding on the.
Absolutely, ICJ order is binding, and to what extent the state has to take action, it all depends upon the judgment of the ICJ. That's why in Kulbhushan Yadav's case, consular access has been given to India. Indian officials, the Indian mission approached the Kulbhushan Yadav, met him. They also took his wife and the family members to Kulbhushan Yadav. So it all depends upon the how judgment is made by the ICJ.
Yes, sir. Thank you, sir.
గారు మాకు ముఖ్యమైన ప్రాబ్లం ఏంటంటే ఫ్రమ్ ది సైడ్ ఆఫ్ పోలీస్ అండ్ ప్రాసిక్యూటర్స్ మాకు ఇక్కడ స్టేట్ ఆఫ్ ఆంధ్రప్రదేశ్ లో ఎక్కువగా ఈ ఇన్సైటింగ్ ఆఫ్ వైలెన్స్ బిట్వీన్ గ్రూప్స్ అని కేసులు కడతాం. బేసికల్ గా ఏంటంటే ఈ సోషల్ మీడియాలో అప్స్కిన్ పోస్టింగ్స్ కానీ వల్గర్ పోస్ట్స్ కానీ ఇవన్నీ వేస్తున్నారు. వేసిన తర్వాత ప్రాబ్లం ఏమవుతుందంటే మేము ఇక్కడ నోడల్ ఆఫీసర్ ఉంటారు, వాట్సాప్ కానివ్వండి, ఫేస్బుక్ కానీ, ఎక్స్ కానీ, వాళ్ళు ఏమంటారు, వాళ్ళేమో మాకేం సంబంధం లేదు, ఈ అన్ని సర్వర్లన్నీ యూఎస్ లో ఉండి వాళ్ళకి రిక్వెస్ట్ పెట్టాలంటారు. వాళ్ళు రిక్వెస్ట్ పెడితేనేమో ఎటువంటి కమ్యూనికేషన్ ప్రతిదానికి లీగల్ డాక్యుమెంట్ కావాలా, సపోర్టెడ్ బై లా అంటారే తప్ప మా యుఎస్ లాస్ పర్మిట్ చేయవు అంటారు. హౌ టు సెక్యూర్ దట్ ఇన్ఫర్మేషన్ ఫ్రమ్ దెమ్ అనేది మాకు పెద్ద బిగ్ ప్రాబ్లం.
Sir, one way is you can invoke the MLAT route between India and USA, and there are some new guidelines issued in this regard by MIT, Ministry of Information Technology, Electronics and Information Technology, issued some guidelines regarding social media. I think they are applicable from 1st January 2025. Those guidelines also plays a role in handling or tackling of your issue, which imposes an obligation on the administrator of the group or the Meta, that is the operator of the WhatsApp group or any social media group. They own a responsibility. In fact, this was an issue raised before the Delhi High Court also, when the chief of the Google was summoned. He said, "I am not responsible. I will not answer." But the court held that no, you have to give information. You have to share the information or the details, because it is your platform on which these messages are put. So therefore, the WhatsApp group cannot say that I have no responsibility and I'll shirk away from responsibility, because it is my platform. Like the way, I'll give an example, sir. Amazon is a platform. On Amazon, various traders, various persons are selling their goods. Amazon as such is not selling goods, but Amazon facilitating the sellers to sell the goods. Amazon is only a provider, service provider. So Amazon also owes a responsibility. You must ensure that the service providers whom you are facilitating are genuine. That is why the written policy and all these things. Similarly, social media platform operators own a responsibility. If some communication is put on them, they have to test the veracity, and that is why the responsibility lies on the administrator as per the new guidelines are concerned.
Can we insist in nodal officers who are nominated in India to furnish such information?
Directly nodal officer, you can ask nodal officers, you can seek the help from the nodal officer. That is why time to time there are some guidelines also issued. In case if there is any such communication received, you please contact, you please appraise. For example, with reference to the cyber crimes and cyber this digital arrest, etc. Time and again people are cautioned to approach some particular number. Even recently, I think the Andhra Pradesh police has cracked one case in this regard, which became an issue on social media, receiving appreciation from across the sectors. Yes. So it all depends whether the national director, coordinator is, to what extent is responsibility we have to pursue from the angle of the case and the facts.
So far as matrimonial offences, we are facing a big problem with regard to the 498 and 3 and 4 Dowry Prohibition Act. So many states are unable to execute. That's now it seems they are giving orange warrant instead of previously they are giving blue warrants. Orange red corner notice. What that US law saying that it is not an offense in US. That's why they are declining their consent. How to come across?
That's a problem I also mentioned, sir, with reference to this. Even if you ask them an extradition, they adhere to the principle of dual criminality. Unless it is a crime in their jurisdiction, they will not extend any cooperation. Recently, this issue was also debated and discussed with the Foreign External Affairs Minister also. So we have gone to the extent of even exploring the possibility of impounding of these passports if he is an Indian. Suppose if is involved in offense of some matrimonial offense, this is abnormally very high when compared to South. In case of Haryana and Uttar Pradesh, these cases are very high. Punjab, because many people, they come to India, they marry a girl for 1 month or 2 months, and then they'll take them and they're using them as servant maids or the domestic help there. He's already married there, but he's coming here and marrying another girl and taking them. So these kind of cases are abnormally increasing, and there is one amendment is also proposed in this regard, and you have gone to the extent of impounding of their passports. But again, as you rightly mentioned, unless it is an offense in their territory, that's why I gave an example of this black money also. Black money is not an offense in many jurisdictions. Not tax evasion is also an offense. It's not an offense. But in India, it is an offense. If you evade tax, it is an offense. But in many countries, it is not an offense. So this challenge we have to meet. You have to pursue them from the angle of. That's why I mentioned one of the core challenges about this MLAT is about the legal, political, social structure is also very, very important. So you have to pursue with them that how it is an offense, it can be constituted under their jurisdiction, and you have to change the nomenclature and then seek their assistance.
There is any provisions for the individual to initiate to block the defamatory or derogatory videos or for postings in the social media?
You can complain to the concerned administrators. Even in Facebook, I made several complaints. Even in WhatsApp, I made several complaints that this is an unwarranted message sent to me. Of course, this you can do if it is an individual to individual. But if it is from a group, again, the administrator of the group owns the responsibility. So in such case, the responsibility lies on the administrator of the group who is allowing to circulate that kind of information. Even I am a member of some groups. In that group, I always alert that there should not be any unwanted or unwarranted political or defamatory messages in the groups, because we don't know the veracity of the message which we will be sharing. It's like its authenticity is a big question, sir, because WhatsApp is like a dustbin. Somebody will put his dust into it, and this gentleman will put his dust into another group, just circulating the dust among the groups. So therefore, authenticity is very important. I think new guidelines is addressing this aspect. The new mighty guidelines is addressing this issue, sir.
The social media platforms not responded to the request of the individual. What are the remedies to open?
You can complain to the authority as per the mighty guidelines if he is not responding. That's why I gave an example of calling the presence of the Google chief. Even they refused to appear before various committees. When the committees summon them to appear before them to give explanation why they are not responding to this, then there is a threat that we will be closing their platforms in India. Even we have blocked some platforms in this regard when they are not responding. So you can make a complaint to the mighty authorities that this is the complaint and this is the issue. And there is a separate wing dealing within the Ministry of Electronics and Information Technology dealing with this. You can make an approach, and if you don't get remedy, you can invoke the legal course also against them that this is the position and this is the non-action on the part of this. It's a non-feasance on their part, so they are liable.
Krishna Kishore?
సార్ నమస్తే సార్.
నమస్కారం
సార్. ఏ సందర్భాల్లో లుక్అవుట్ నోటీసు, రెడ్ కార్నర్ నోటీసు ఇష్యూ చేస్తారు సార్?
I explained you. I just explained you before this. See, gravity you have to establish. You have to come up with a reason for issuing of this red corner and lookout note. Suppose if he's involved in serious crimes, serious offenses like fraud, any serious offense, which may be threat to the nation, fraud, corruption, or any issues, are involved in some scam, you have to justify for issuance of lookout notice. Lookout notice is basically to restrain his movements or restrain his shirking away from the responsibility or flying away in other zones, or to keep an observation when there is a possibility of escape, when the possibility of involving some scam or some big serious issue, then you can. If it is having some international issues, then you can seek the Interpol about red corner notice. That is, his entry will be prohibited, his restriction, his movement will be restricted to a particular position. So it all depends upon the facts and circumstances. We cannot say that this is the case where only in this case you can issue the lookout notice or red corner. It all depends upon the facts and circumstances what you frame.
Irrespective of offenses, sir.
కిషోర్ లుకౌట్ నోటీస్ ఇచ్చేది ఇక్కడ ఇన్వెస్టిగేటింగ్ చేసి సార్ చెప్పేది అంటే లుకౌట్ నోటీస్ ఇచ్చేది ఓన్లీ ఇక్కడ ఇన్వెస్టిగేటింగ్స్ ఇక్కడ మన ఇండియా దూరంగానే పట్టుకుంటారు. రెడ్ కార్నర్ నోటీస్ అనేది చార్జ్ షీట్ వేసిన తర్వాత ఎక్స్ట్రాడిషన్ యాక్ట్ లో అఫెన్స్ అయితే అక్కడ అఫెన్స్ అయితే అప్పుడు రెడ్ కార్నర్ నోటీస్ ఇస్తారు. ఆఫ్టర్ టేకింగ్ కాగ్నైజ్ రెడ్ కార్నర్. లుకౌట్ నోటీస్ ఓన్లీ ఇండియాలోనే పనిచేస్తుంది, వేరే దేశాల్లో పనిచేయదు. అది ఓకే.
It is only at your borders you can look out. At your borders you can look out at airports, railway stations, or bus stand. That's a lookout notice. Lookout means just have a surveillance where he is moving, how he is moving.
When you found in Indian airport, you will be caught immediately. That is next అండి. From the side of police. ఇంకేం డౌట్స్? ఇంకెవరు ఉన్నారండి? రామాంజలి గారు మీరు ఏమైనా అడుగుతారా? చూస్తున్నారు రామాంజలి గారు.
సార్, ఇదే విదేశాల్లో చాలా మంది మన దేశంలో చేసిన నేరస్తులు విదేశాల్లో ఉండిపోతున్నారు. వాళ్ళని తీసుకురావటానికి చేస్తున్న ప్రయత్నాలు చేస్తున్నారు. కానీ ఆశించిన మీద ఇప్పుడు విజయ్ మాల్యా వీళ్ళందరూ ఉన్నారు. మనకి ఇన్ని మ్యూచువల్ లీగల్ అసిస్టెన్సీ ద్వారాగా మన ప్రయత్నాలు అవి ఎక్కడ వాళ్ళు తీసుకొచ్చి కోర్టులో ప్రొడ్యూస్ పరిస్థితి కనిపించట్లేదు.
కనిపిస్తుందండి. That's what I mentioned. మీకు Canada example also I gave. That Canada example, 3 persons they challenged it. When court intervenes, when court passes an order, your MLAT is of no use. In Vijay Mallya's case, our extradition requests were challenged. Our legal assistance was questioned before the UK courts. Now the courts have cleared very clearly, unambiguously, that he is liable to be extradited. The order is passed. So very soon he may come to India, he may be extradited. Now the way is cleared, there are orders passed. Because the problem in Vijay Mallya's case, or in Chuski's case, or any other extradition case or legal assistance case is, if they challenge the very request before a court of law, if the court of law of that jurisdiction entertains that petition, then we cannot ask that court, don't decide this, you hand over him to me. That is not the provision of the MLAT. MLAT won't allow it if it is related to some proceedings in the court of their jurisdiction. That is what had happened in case of Vijay Mallya. Vijay Mallya challenged it at every level. He knows that there is a foul game played by him, and that is why he took shelter. And the problem is, again, it is also depends upon the socio-economic, political, legal structure of the jurisdiction. Vijay Mallya knows the position in UK. In UK, if you enter into their territory with a valid passport and valid visa, you will have protection under their jurisdiction. Suppose if I go there, if I landed in UK territory, I am having a protection there by virtue of the visa accorded to me. And I am also amenable to their jurisdiction for all legal recourse, as long as I enjoy this permission. This is what had happened in case of Vijay Mallya. He questioned our action before various courts. Same thing happened with Chuski also. Now Chuski is filing a petition that he is suffering with some ailment of cancer or something, he requires a treatment. The point here is, in criminal administration system, we know sometimes the criminals are involved and he is the man who committed this offense. But still we are helpless because we are crossing our fingers because of the procedural requirements that we need to follow under the law. The delay is because of the procedural requirements that India is following.
Thank you, sir.
Letter of think the court cannot issue directly to the other country court without the intervention of the government of India.
It can. Letter of regulatory can be sent. That letter of regulatory will be sent to the central authority again.
Again, only the central has to give consent for that also.
Yes. Yes. No, we will not reject the letter of regulatory. Earlier, the procedure is through diplomatic channel. The judge has to send that letter to the concerned mission, and the concerned mission MEA has to forward it to the mission in the jurisdiction. That is a procedure. Now that procedure is changed. It is through central authority. If they send it to letter of regulatory to us, we will forward it to directly to the concerned central authority.
Now the court can issue summons to nodal agency directly without the intervention of the.
No, government intervention is there. Central authority is there under the Hague Convention.
Okay.
Under the Hague Convention, Hague has
it seems in letter of regulatory also we have to send all the documents along with the summons.
Not all the documents, but some important documents relevant to the request you have to. You need not give the full description of the case or the facts and everything, but give the small brief detail about this for the enabling the central authority to understand what is a case. Because it is
request, not for other requested court.
Yes. For example, recently, the issue of the Foreign Exchange Regulatory Commission passing some order and serving summons in case of Adani, that also to come through central authority.
Okay. Any more, Andy? Okay. Now I request Mr. Ajay Kumar Lam, Public Prosecutor, Nelluru, to convey vote of thanks to our chief guest and keynote speaker, Sri Ram Jogarao.
Sir, thank you very much, sir. I feel it is an advantage to participate in prestigious meeting, and I'm given a chance for voting thanks Mr. Dr. Kasibatla Ramajogaya Garu on his deliberations on mutual legal assistance. I personally thank our Honorable Director Baira Ramkoteswara Garu for taking a schedule for sharing the knowledge of an international personality, even in the busy schedule of Honorable Resource Person. The eminent speaker efficiently explored all areas from basics to make the participants to know the subject in a better way. The arrangement of topics show the capacity and caliber of the speaker to deliver the lecture. Generally, EMLA is new to our prosecutors as we deal most of the time on criminal major acts, local and state laws. It is the need of the day to enrich every one of us globally, for which this type of lectures and sharing of knowledge by eminent persons and persons with special knowledge. Every time, it may not be possible to get a man of legal encyclopedia like our present guest. It is another notable thing is that our speaker is not only Telugu person, but also the friend of our Director of Prosecutions, Baira Ramkoteswara Garu. A Telugu person reaching such a heights academically and professionally is applaudable. I thank Dr. K. Ramajogaya Garu on behalf of all the prosecutors and the Director of Prosecutions and the Directorate of Prosecutions for his great patiently giving lecture on an internationally crucial, important topic. I also thank our Director of Prosecutions, Baira Ramkoteswara Garu, for his introduction on topic, and also to thank him for his efforts in bringing all scholars and making the prosecutors at the state level to get well with the tools already they have and to improve themselves well legally equipped. I also thank our director for linking the YouTube for revising, recollecting, and rechecking for any query by referring our YouTube about topics already dealt. I thank Jahnvi for giving introduction very well in depth about our guest on present topic. The curriculum and professional introduction by her is very great and inspiring. I thank one and all who participated in this program. I thank Baira Ramkotisrao Garu for giving this opportunity to me. Thank you, sir.
Thank you, Jogara Garu. Thank you very much.
Thank you. I must say thanks to my dear friend.
We'll utilize your services with intellectual property, which is also very essential for us.
I'll be happy.
Nowadays, intellectual property is a big subject for the prosecutors with regard to the Copyright Act, Trademarks Act, or so many acts are there. We'll use your service and another time with regard to the intellectual property. Thank you very much, Jogara.
I'm open for my dear Koteswara. Thank you very much.
Okay, thank you.
Thanks for all of you for your affinity and affection. I'm very happy and glad.
Yes, sir.
Thank you all. Wish you all the best in your
Thank
career
you,
and
sir.
success in your every endeavor. Thank you very much.
Thank you.
Thank you.
Thank you.